The petition was basically on 4 grounds. That land, definition of land is not within 2F. Then section 4 and 5 were violated. Question of estoppel, and the last is notice. We have accepted the 3 grounds. We have not accepted the first 3 grounds, but on the ground of notice, we have allowed the repetition. In view of the aforesaid discussion, this court is of the view that though the other contentions of the petitioners may not be held to have any merits, the repetition would succeed on the aspect that no notice has been served on the entity, namely the petition number 1, which was an existing LLP much before the impugned proceeding was initiated under the Act of 1956. Repetition accordingly stands allowed. Since the interference is only on the point of notice not being served on the legal entity, it will be open for the respondent authorities to proceed afresh, which however has to be done in accordance with law.
Deeply obliged.
May please, Lord, due to certain urgency, can I make a prayer for taking up this matter at 2 p.m. my Lord?
Motion.
Motion.
Urgent.
Some
What is that?
My Lord, in fact, democratically, my Lord, elected president of a Gaon Panchayat now is sought to be unseated by the deputy commissioner by passing an order which is in conflict or in violation.
Order is of which date?
My Lord,
Order is of which date?
my Lord, 3-4 days back, my Lord.
What?
My Lord,
We
now
cannot-
what has happened, my
We
Lord?
cannot stay an order of 3-4 days back.
No, my Lord, now
We can have it. We can
handing
have
over,
it.
my Lord, taking over has not, my Lord, it has not taken place. Once it takes place, my Lord, complications, my Lord, any consequence will my Lord, follow. So,
Don't
I'll,
ex-
my Lord,
don't
hardly
expect
I'll
any-
take 5 minutes, my Lord, time of your Lordship's
Don't
time.
expect an interim order. We'll allow it for moving. Move it at 2
Well-
o'clock, but don't expect an interim.
My Lord, I'm deeply obliged, my Lord.
Yes.
My lord, I'm praying for listing next week, any date, my lord.
What matter?
Relating to cancellation of registration, my lord.
Cancel of registration. What
It
is
was
the
last
urgency?
listed on 4th, 6th month, thereafter it is not listed.
Not by out of turn listing.
My-
Only motion.
my-
Or if out of turn listing, it has to be urgent. Yes.
Miller, I beg to mention for listing admission matter, Miller. 10 ward members, Miller.
Last listed last when?
25-6, Miller. Returnable 4 is Miller, not listed.
You make an application to the registry.
And next week, Miller, any date, Miller.
Little accommodation, lordship, can it be at item of 45, 44 and
44.
40, at 2, lordship, I have some, if possible, lordship,
Yes.
at 2, lordship.
What is the matter about?
But the matter was actually, they have filed a stay vacation petition.
Okay, we'll have it at 2 o'clock. Have you informed the other side?
He is,
Okay, no problem. Yes.
May please, Lordship. I beg to mention item number 12, Lordship.
12, yes.
Yes, Lordship. Mr. Yashida will event, but he is out of station, Lordship.
Who is out of station?
Yashida, Lordship.
Okay. Yes, informed, you have informed BTC, PWD?
Yes, Lordship. It is a. Any date, Lordship,
On
after 8.
on a request made on behalf of 3A R Sigdar, learned counsel for the petition and matter is adjourned to be listed after a week. Yes. Petitioners.
May it please, your Lordship.
Yes,
Lordship, I beg to mention item number 16,
16.
16,
Yes.
Lordship. In this matter, some of the annexures inadvertently got missed to be annexed, Lordship. Can I file an affidavit, additional affidavit with the annexures? Lordship?
Yes. On the prayer of Sri P. Barua, learned counsel for the petitioner, matter is adjourned by a week to enable filing of additional affidavit to bring on record certain relevant documents.
Lordship. Much obliged.
Yes.
May I please, your Lordship? May I please, your Lordship? My Lord, I beg to mention for listing of a motion item for my Lord eviction matter on Monday. My Lord, and another of the Panchayat matter, my Lord.
Motion.
Motion, my Lord. Oblige, my Lord.
Panchayat, what is the urgency in
My Lord,
Panchayat?
we are the 7 members, my Lord. Those we have selected the president. He has not been.
Okay, motion, okay, no
Fine.
problem.
Oblige.
May please, your Lord. Lordship, item number 17, my lord.
17, yes.
17. I am praying for withdrawal.
Being for
Withdrawn.
withdrawing. What is your name?
Yes, Ahmed.
Yes, Revenue Department, yes. Sri A.S. Ahmed, learned counsel for the petitioner, submits that he has instructions to withdraw this writ petition. Also heard Sri N. Das, learned state counsel, and Miss G. Hazarika, learned standing counsel revenue, who do not object to the same para. Writ petition is accordingly dismissed on withdrawal. Yes.
Obligation.
Right, please, your lordship. My lord, I beg to mention a GST matter for admission hearing on 17th of this month, my lord. It is a covered matter and connected cases have been already disposed of 6 months back. And this case is
State
language
GST or central GST?
GST, my lord.
State,
No, my lord, says GST, state GST.
state GST.
Yes, ma'am.
Anyone from the finance department? What is the matter, Mr. Gogoi? Is it covered? What is the matter?
TNS. Demand notice. The demand notice has been not yet been passed. It has long gone past the timeline, mandatory timeline.
Is it covered, Mr. Gogoi?
That's of course without the file.
When are you praying for?
17th.
Let it be on the file.
So
Yes, okay, 17th. Let us see. Yes.
Please, your lordship. In respect of item number 38,
Yes.
I got instruction for withdrawal this case.
What is your name?
Sir, Deepshikha Deka. In Wakalatnama, Divyansh Rathi's name was there.
Your name is there or not? No.
No, sir.
Miss,
My senior.
Miss so-and-so, naam lijiye. Learned counsel appeared in instruction of Sri Divyansh Rathi. Counsel for the petitioner submits that there are instructions from the petitioner not to press this petition. Also heard CGC, any CGC in the court? Any CGC, Mr. Das? CGC. Also heard Miss Egan is there, otherwise RKD Chaudhary.
I have not seen Kiran.
Egan also heard Miss Egan, Learned CGC. Correct. Petition is accordingly dismissed on withdrawal. Okay. Withdrawn. Yes, but take her name, huh? Right? Tanda? Naam to the over.
May I please, your lordship? Lordship, I beg to mention for listing of a matter that was last posted on 4/4/25.
What is the matter about?
Land matters, lordship.
What is the urgency?
Lordship, the matter has not come yet.
That is not an urgency. No out of turn listing. Yes.
May it please, your lordship. Lordship, I beg to mention item number 35 for accommodation for a day, lordship. Let it be come after vacation, lordship.
Okay, you have some difficulty today.
Yes, lord.
Okay.
Yesterday, we have circulated our adjournment slip, lordship.
Why this review?
For condoned delay, lordship.
No, why this review?
For compensatory appointment, lordship.
Order passed by this court. Initial order passed by this court. Should
I
know
I
at
have to
least
take instruction from senior, lords.
on a request made on behalf of the applicant, matter is adjourned to be listed after a week. Yes.
Obliged, lordship.
Yes, madam?
One is I beg to mention item 32.
Yes.
Order is already complied with, my lordship. We want to withdraw the matter.
Okay. Mr. Gogoi? Where was he? Miss Ann Borman,
Yes, my
Learned
lordship.
counsel for the petitioner submits that during the pendency of this petition, the order dated so-and-so, passed in so-and-so has been complied with. Also heard Sri B. Gogoi, Learned counsel for respondent number 2, para.
Yes, sir.
In view of the aforesaid submission, comma, there is no requirement to continue with this petition, which is accordingly closed. Contempt. 32. Yes.
May it please, your lordship, I beg to mention two petition, lordship. It may come up in the orders column, lordship.
Two writ petitions for what are these two writ petitions?
Lordship, for a non-finalization.
Where
of
is
the
your
process
mention memo?
Allotment.
Where is your mention memo?
Lordship, my colleague is,
So you'll bring the mention memo in installments.
no,
Then
he is writing it, lordship.
it's not like this. You're a young counsel. Don't make a mention with a mobile phone for listing. Where are your mention memos? Don't have that audacity to have make a mention. You should be vigilant. You have to have the mention memo, whether we allow it or not, that's a different matter. It's not like that.
No, senior instructor just now.
It's not like that. And what is the urgency?
Lordship, it is for non-finalization of the process of allotment of land, lordship.
Not urgent. And don't make a mention like this. Yes.
Lord, the operative direction is at page number 59, Miller.
Paragraph
Para
42.
42, yes.
42. Yes.
In view of the discussion and observation made herein above, I am of the considered view that impugn order dated 26/3/21 passed by the Secretary to the Government of Assam, Agriculture Department and Chairman of the Committee constituted for allotment of group shop, whereby application for allotment of group shops of the petitioners are rejected on the ground of non-fulfillment of required criteria under clause number 4B of the guideline for allotment of shops to eligible wholesalers in the fruits and vegetable market at Pamuhi by the committee, constituted by government notification is not sustainable and thus deserved interference. Accordingly, impugn order dated so-and-so passed by the Secretary to the Government of Assam Agriculture Department and Chairman of the committee is hereby set aside. Consequently, the respondent authorities are directed to reconsider the case of the petitioner in accordance with the guidelines, particularly clause 4B, and if one of the document required is submitted without insistence on the year of the document for allotment of the room shops at fruit and vegetable wholesale market at Pamani, within a period of 6 weeks from the date of receipt of a certified copy of these orders. It is made clear the above direction is issued after considering the fact that petitioners found to be victim, evicted wholesaler of Artswell Masqua market. So, my lord, in spite of receiving the order, my lord, they have not taken any action till yet.
But who will take the action?
My lord, basically the committee, wherein, my lord, the Secretary Agriculture is there, Commissioner GMC is there, Deputy Commissioner Kamrup is there.
The present respondents.
Yes, yes.
Heard
all the-
Sri K. N. Chaudhary, Senior Counsel for the Senior Counsel assisted by Sri NNB Chaudhary, Counsel for the petitioners who have complained of willful and deliberate disobedience of the order dated so-and-so passed in so-and-so. The learned Senior Counsel has also drawn the attention of this court to the aspect that the order in question was furnished to the respondents which have been duly acknowledged. Let notice be issued, returnable by 6 weeks. Served by state prosecutor within 2 working days. Yes, sir.
Deeply well. Deeply.
Lordship, item 2, I beg to appear virtually, Lordships.
Yes,
Lordship, this was taken by your Lordships on 25th of August, 27th of August, when my learned opposite side had sought some time for instructions.
volume nahi. Volume nahi. No, it would no, not there.
Is appearing from DC.
You have to increase your volume. We're not very audible.
My lords, I'm not audible, lords.
Not very audible. Can you increase your volume?
My lords, it is showing in full volume in my system.
Okay, what is it?
Lordship, this was regarding the export refund, which was not given by the
Yes,
department.
you were
It's
given
a
you
second
time
round
for
of
some-
litigation.
Instruction is still awaited. Lordship, I may be given 1 week time, Lordship. The matter has been placed before the appropriate authority.
This was done on the last occasion, 27/8.
20, Lordship,
And,
it's
the
the
learned
second round of
counsel had-
litigation.
What is your challenge?
Lordship, my challenge is, Lordships, as per section 54 of the CGST Act, read with section 16 of the IGST Act, any exports that I do with payment of GST, the process is an automated process of refund, wherein once I file my GST returns, I will be.
Mr. Jain, can we issue notice at this stage?
Lordship.
We will issue notice.
Lordship.
No point granting you time to have the instruction. We'll issue notice, Mr. You are Kanodia.
Lordships.
Heard Sri A. Kanodia, learned counsel for the petitioner who has appeared online. First up, the grievance of the petitioner is against the inaction of the Superintendent Customs, Land Customs Station, Hatisar, in not granting the IGST to the petitioner has been paid on export of goods during the period June 2020 to July 2020. Full stop. It has been contended that even after expiry of more than 6 years from the receipt of such representation and reminders, no action has been taken. Why have you come to the court so late, Mr. Kannada?
Lordship, this is the second order, Lordship. The first order is on page number 65.
The petitioner had earlier approached this court by filing WPC 5185 of 2021, which was disposed of by the order dated 17/11/2021. Full stop. However,
Lordship, para number 8 of the judgment gives me liberty if they still don't do.
that notice be issued, returnable by 4 weeks. Sri K. Jain, learned counsel, appearing on instruction of Sri S.C. Kal, senior standing counsel, CGST, accepts notice.
Customs Department.
Sending counsel, customs, accepts notice on behalf of all the respondents.
Lordship, the law and Lordship, may I just say one thing, Lordship?
Let extra copies be served upon him within 2 working days. The commissionerate is not a party, Mr. Kanodia.
Lordship, the superintendent, the principal commissioner is the party.
No, the commissionerate as such, he has
Lordship,
made the officer a party.
No, Lordship, the commissionerate is a party, Lordship. The principal commissioner, Shillong Customs Commissionerate.
Now, where is the commissionerate as a party?
Lordship, commissionerate is represented by the principal commissioner.
Have you written as such, commissionerate represented by the principal commissioner? You have written in the reverse order. The legal entity is not before the court.
No, legal entity cannot be, Lordship. I apologize for that. I apologize.
If you think you can file an amended cost title, because this problem may arise if it comes before this court. We tell you in
Lordship, I will.
advance.
Lordship, may grant me that liberty. I will do done it.
Okay, your colleague will take steps. Okay.
Grateful, dear Lordship. Much obliged.
Last customer instruction was sought for me regarding this covered or not, man.
Can it be at 2 minutes? Or on Wednesday?
At 2 o'clock?
At 2 minutes. 3 and 4 same minutes.
Please look into if it is covered, then there's no point of adjourning.
Obliged.
Yes, Dr. Saraf?
Well, in this case, Miller, a order for authorization for search was passed, which you also find page 54. As you also got it, Miller.
You were aggrieved by the search and seizure order 2012, 2024.
Search and seizure, Miller. I'm dealing with the medicines, Miller.
Yes.
Life-saving medicines which are to be supplied all over the country. Now, there was no medicines was found to be unaccounted. There is no account, all are accounted.
Well, issue notice
The only thing is that
order of 2024-12.
no, Miller, the difficulty is, Miller, 24/12 is for itself. Seizure was there. Subsequently, Miller, the notices were issued, going documents and all those things. Now, out of the seizure goods, Miller, 2 lakh, 30 lakh, 20 lakhs have already expired. And about 70 lakhs, they are going to expire within five months, Miller. My difficulty is that, Miller, they are not completing the dredging the tax demand, nothing. Now, I was ready to give a bond for the tax amount, whatever tax amount, although the full tax amount will not be there.
Yes, can you have the instructions?
My lord, on Wednesday.
We can have it on Wednesday because he is pressing for an interim order. And he's also made it very clear that he's willing to give a bond for the
tax amount.
For the amount which
the tax amount will not be full because the tax has been paid, but I am ready to give the tax bond. But medicine cannot be it cannot get expired all.
My lord, on Wednesday in that case.
Okay. Heard Dr. A. Saraf, learned senior counsel, assisted by Sri P. Barua for the petitioner. Sarah? Considering the nature of challenge and the submissions made, this court directs Sri B. Gogoi, the Learned Standing Council, Finance Taxation Department, to obtain instructions. Full stop. Let this matter be listed for motion
And in fact, the bond,
on Wednesday,
well, the bond was submitted, but it's been the end of the region.
10th.
Bond was also submitted, no?
Okay. When did you submit the bond?
Well, it is there, no? I copy also I have annexed, no?
Or you can consider that aspect if the
Yes,
bond is there. Okay.
It has not been released. Because they say, well, the entire value of the goods, you give the guarantee, well, entire value of the goods is all accounted, there is no provision.
Okay. Wednesday.
My lord. 15.
Yes, Mr. Chaudhary.
May I please the Lord? My lord, petitioner filed a CR case, my lord. CR case was forwarded to the police station for registering a case, my lord.
You filed a what?
CR case, my lord.
Complaint.
Complaint, my lord.
Yes.
Then complaint was forwarded to the police station for registering a case. Order was not complied. Then again, my lord, petitioner filed a CR case, my lord. Then again passed an order. Your lordship will find page 21, my lord. Relevant portion, my lord, page 22, bold portion, my lord, kindly see.
Where is the order of the learned magistrate?
My lord, this is the order. My
Page
21, my lord.
21.
21, my lord.
Please read.
My lord, operative part, page 22, my lord. Bold portion, my lord.
22.
22. It is strange that this police officer neither registered any FIR nor investigated the matter. Rather, he reported that he did not find any CR case was found in his police station. Hence, taking a serious note on the matter, I direct the officer in charge, Ramnathpur Police Station, to immediately register the FIR on the basis of complaint petition so and to investigate it matter and submit the final form.
This was on in June 2025.
25, my lord.
In March 2025.
25.
Thereafter, what happened?
No action has been taken, my lord.
Yes, sir.
Copy has not been served to us.
Copy not served. Your names have been, I think, names not so, no what?
My lord, I'll take instruction, my lord. Let the copy be served, my lord. Yes, sir.
Will issue notice, short notice. Heard Sri A.H.M.R. Chaudhary, Learned Counsel, for the petitioner whose grievance is the inaction of the respondent number 3 to adhere to comply with the order of the learned magistrate dated 7/3/2025 on the aspect of taking action on a CR case 1214 of 2023 under sections so and so, side of a sections. Let notice be issued, returnable by 4 weeks. 3, and thus London State Council accepts notice on behalf of all the respondents, extra copies within 2 working days. Yes. Bring the instructions. Maybe some action has been taken. Give extra copies.
That here in this case, notice under section 3(1) of this Acquisition and Requisition Act issued. My lord, my humble submission before your lordship, that the provision of 3(1) of the law, that section 3(1) is violated, my lord, in the notice. Because, my lord, it is for the purpose of, may I read this, my lord, provision?
You are referring to the 1964 Act.
1964.
Yes.
1964, section 3, my lord.
Just a minute, please.
For providing land, my lord, from middle, individually or in group to landless, flood affected or displaced person or to society registered under Assam Cooperative Societies Act or a company incorporated under the Companies Act or company incorporated under Companies Act 1956 formed for, that is important, my lord, formed for benefit and rehabilitation of landless, flood affected and displaced person or provided land for purpose of construction, border road, etc. Now, your lordship, here the notification issued in Form A, my lord. I'm drawing your lordship's attention to Form A,
Page?
page, my lord, 357, this book, my lord.
No. The notice here
My lord,
at page 18.
my lord.
Is it
For-
18?
Form A, my lord, yes. Page 19.
19 or 18?
My lord, type copy in 19, my lord. Here, my lord, in the Form A notice, it is said, for construction of power project under Sapor Revenue Circle. So, my lord, section 3A, 3(1), my lord, does not provide for power, my lord. It is for border fencing and landless person. So, my lord, this form, your lordship will find in the rules, my lord. My lord, rules Form A. Form A, your lordship. That
For
So-
providing proper facilities for accommodation,
Allied works.
allied works.
your lordship would be pleased to see. Where the land described in schedule here
Yes.
to annex is necessary to requisition and is proposed that the said land should be requisitioned for providing land to landless or displaced person. I am reading from rule, my lord.
Yes,
Form A.
yes.
The proposed that the said land should be requisitioned for providing land to landless and displaced person.
Yes.
Now, your lordship will turn to page 19.
Hmm.
Here, my lord,
Yes.
that form is not properly used, my lord. That they say for construction of power project.
Yes.
Here it is said providing land to landless and displaced persons. For power project, 3(1) is not there, my lord. 3(1) for landless person, my lord, and for border construction. For
Yeah.
giving company, this provision is not.
Will you go by the form or will you go by the contents?
Well, contents, your
passed,
lordship,
some
contents, your
judgments.
lordship, is 3A, if we read section 3(1), my lord, along with this form, then there is similarity. But what the authority did, my lord, they skipped from the form.
We have passed some judgments that this form is not, if we will go by the contents,
My lord.
the form is only.
Form may not be.
Facilitation, how
But
do you,
section 3(1)
go
is
to section
clearly
3.
violated, my lord.
how is 3 violated?
Yes, my lord, section 3 says it is for landless person.
Please
Purpose,
read, if in the opinion of the state government.
Yes,
or
my
any
lord.
person authorized so and so.
Yes,
It is
my lord.
necessary for maintaining supplies
Yeah,
and services essential to the life of the community or for providing proper facilities of accommodation, transport, communication, irrigation, flood control and anti-erosion, including embankments, so and so, individually or in groups. These are all
and
disjunctive.
drainage for providing land or
These are
for
all
providing
disjunctive.
land. Now, my lord, my humble submission before the lordship.
Incorporated
Actually, my lord,
under the Companies Act.
actually, my lord, we are landless people. We have parcel of land, my lord. We are patta holder. Now the government decided that we take the land. Then if they take the land, my lord, we will be landless. Now your lordship would be pleased to see, we have been given 15 days time to file representation.
Yes,
In page 19 itself, my lord,
yes.
interested, I hereby call upon to being person interested in the said land to make representation within 15 days.
Yes.
That 15 days time is given. Now, my
Have you
lord,
considered the representation, Mr.
we
Das?
have filed this representation, my lord.
2/7.
Yes, we filed
2/7.
representation, my
On
lord,
2/7.
within time.
That
Within
was-
time, that
that-
is not disposed of, but thereafter, my lord, one after another, they
Can be,
issued the
direction
notification.
may be passed to disposal.
My lord,
Within a time frame, my lord.
Within a time frame, my lord, if my representation is disposed of within a time frame, giving speaking order to me, in that case, my lord, till then, my lord, I may be protected. Without, my lord, that is their contention that you file representation. I file representation within 15 days. They are not disposing of, and thereafter, my lord, they are continuing to.
If it is a
issue notice.
patta land, they will be compensated, my lord.
No,
2013 Act will come into
compensation
play.
is another matter. So, to that, my lord, my humble submission before your
If they are
lordship,
patta land.
as your lordship aware of, that 1894 Act, Land Acquisition Act, has been repealed by Act of 2013, that fair compensation. In the fair compensation, my lord, it is provided that if a person go homeless, then under Indra Awas Yojana, some house is to be provided in the rural areas. That is the provision, my lord, in the schedule of that Act, 2013 Act, my lord.
Where is
So-
your representation?
My lord, representation, my lord, I'm doing.
On this.
Okay, you dispose of the representation.
Yes, madam.
We grant you 2 weeks' time.
Yes, yes.
2 weeks, do not take any action.
Yes, yes.
And it depends on the outcome of the representation.
yes.
We'll give him liberty to challenge the same if
Yes,
so
yes.
advised.
Yes.
Third, 3, MA Sheikh, Learned Counsel for the petitioners. Full stop. Also heard free, and thus Learned State Council, as well as Miss G. Hazarika,
The representation starts from page 23
Learned
onwards, my lord.
Standing Council, Revenue Department, para, considering the nature of the grievances and as agreed to by the Learned Council for the parties, the instant writ petition is disposed of at the motion stage. Full stop. The petitioners are aggrieved by an acquisition proceeding, land acquisition proceeding initiated wide LA case number 1/2025-26, which has been initiated under the Assam Land within bracket Requisition and Acquisition bracket close Act 1964. Amongst various grounds of challenge, the Learned Council has submitted that Section 3, read with Form A of the said Act, have not been adhered to. Full stop. He has also submitted that pursuant to the notice issued on 10/6/2025, the petitioners have submitted individual representations on
Annexure 4, 5, 6, 7, 8, 9,
what
and
is the
10.
date?
Annexure 4, 5,
Date.
page, my lord, page
Date.
23 onwards, my lord.
Date
Date.
on various dates, which however have not been, comma, according to the petitioners, have not been considered or disposed of. Para. 3, and thus Learned Council, Learned State Council, as well as Ms. Hazarika, the Learned Standing Council, have submitted that if such representations are actually not disposed of, comma, a direction may be given for consideration and disposal of the representation in accordance with law. Full stop. They have, however, stoutly refuted the submissions that there has been any violation of Section 3
Yes.
or Form A appended thereto. Para. After hearing the Learned Counsel for the parties, comma, without going into the inter se merits of the case, it appears that representations were filed against the impugned notice dated 10/6/2025, which, according to the petitioner, have not been considered and disposed of. Para. If that be so, comma, it is that this court directs the District Commissioner Dhubri
Yes, ma'am.
to take on board the representations of the petitioners
Annexure 4 to 10, my lord.
within bracket annexure 4 to 10 of this writ petition, and consider the same and after considering the same, dispose of in accordance with law. Full stop. The said consideration and disposal be made expeditiously as it involves a project of public importance. Full stop.
Maximum 2 weeks, madam.
It's up to you. It's up to you. It's your, you have to do, you can do it within 1 day also. It is provided to balance the equities, comma, it is provided that till such disposal is done by a speaking order, comma, no coercive action be taken against the petitioners. Full stop. This aforesaid direction would be operative only if, in the meantime, the representations have not been disposed of.
Your lordship mentioned regarding requisition act, my lord. I have some grievance regarding 2013 act also, because we have to provide house.
We have not seen anything on merit. Yes, Mr. Sharma.
So here, lordship, the petitioners have a common grievance. So what happens, they are tenant under the Anwaruddin Wakf estate is at Bhang or Guwahati.
They are tenant of?
Of Anwaruddin Wakf estate. They were doing their business, somebody from 1970, somebody, the last person entered in 2021.
Hmm.
So what happened in the year 2023, their agreement was completed. Terminated. After that, they were continuing and they are paying the rent regularly, but suddenly they were asked to vacate the room on the
Yes,
ground.
yes, you take instructions on this, whether there is an account of the Wakf
Yes, sir.
where they can deposit the rent.
Yes.
They have made a statement that on verification, there is no such account found. Okay.
It will be informed from the Wakf tribunal also that there is no such account. Therefore,
Okay, we'll issue a short notice. Heard Sri R. Sharma, learned counsel for the petitioners. Full stop. It is the case of the petitioners that they are the tenants under the Anwaruddin Wakf estate,
Cooperative.
Angaghar,
Judicial.
comma, Guwahati, from a long period of time.
Board of Work of
Full stop.
minority.
In April
This is standing council.
2023, as the mutuali of the estate had refused to receive the rent, the petitioners were compelled to deposit the rent in the court of the Munsif number 1, Kamrup Metro. Full stop. However, thereafter, such rent was refused to be accepted on the ground of lack of jurisdiction. Full stop. The petitioners had accordingly approached the Wakf tribunal.
Yes.
Yes, anything? Mr. Das?
Minority Development Board, I think, my lord, there's this standing council, my lord. Mr. If I'm not wrong, Mr. Mohanto.
Mr.
Mohanto, my lord,
Mohanto
means he's a son of ex-CM, my lord. PK Mohanto. If I'm not wrong, my lord.
কি করো क्या করো তারা করলো একটু নোজে Wakf tribunal by filing. The council submitted that the petitioners had accordingly approached the Wakf tribunal by filing application, which was not entertained, by stating that there was no bank account
yes.
of the Wakf board. The petitioners had again approached the mutuali for receipt of rent, which was initially agreed upon. However, there was a change in the mutuali. Full stop. Now the petitioners are left with no other avenue for deposit of their rent, and accordingly the instant writ petition has been filed. Full stop. Let notice be issued, returnable by 4 weeks. Yes, 1, 2.
My lord, I'm free, my lord.
Huh?
I'm for free.
Why 3? 1 and 2, State of Assam. Judicial Department.
One and two, my lord. not
One and two. 1 and 2. 3, I think, Assam Board of Wakf will have to take by state.
Yes, yes.
1 and 2, so 3, 2, 3, 4, 5, and 6, registered postal AD, tapped within 2 working days. Give extra copies to Mr. Das.
Yes.
Please, your lordships. My lord, in this petition, I have great for the rest of the public, but direction to the respondent authority was sanction and allotment of public road on the south side boundary of the big drain which constructing by the respondent authority, my lord. For development, there is no any road, but it's a
Why don't you
development.
file a PIL?
It's not the form of a PL, my lord.
File a PIL.
But a personal land, our personal land is in cross. With the consent, our land is measured, paragraph 5, my lord. Paragraph 6 may be filled. The petitioner begs to state the respondent authority Petroleum Department after government approval through the Department of Kamrup, Circle of North Guwahati, measured and surveyed the land and fixed the boundary. This is the Dakpata land, our personal land. So we have given consent to measure and construct a drain. Public interest although is there, but our personal land is going to be
So what is your prayer?
prayer for
Personal land, my lord, you can file representation if any.
prayer for to sanction allotment of public road only. On the side of the road, then which is going to be constructed, paragraph 5, my lord. Two representation file, they have not taken action, necessary action.
It's not clear, Mr. Hussain, what you are saying. Who are you? You are the villagers.
Yes, my lord.
You have different plots of land.
Yes,
Then what has happened?
About the land, enforcing the land, the government authority constructing the big drain.
Drain.
Big drain, my lord,
Okay, then,
or development of the area.
then what is
So
your
we
grievance?
we demand that although our land is going to be encroached by measuring the land. So we made a demand that on the public road may be sanctioned allowed by the side of the road.
By the side of the drain.
Drain, my lord. Over our land, not of the department land.
That how are it like? That will be a policy, whether there can be a road, requirement of road.
But there is no formally acquired the land by them. But the lands.
The
also-
acquisition is for construction of a drain. How can you say that it should not be a drain? It should be
But
a
our
road?
fertile land, my lord.
No, how can you decide whether it will be better for a drain or for a road? It is for the authorities to decide. There may be waterlogging
My lord,
effect.
there is no road in the locality or going out or inside the house or place.
Yeah, yes, you take instructions. Not-
Petition is filed by petitioner representing public of the locality along with the authority to file this writ petition. In
Public,
case of
our
the-
land is going
it
to
should
be
be in a
encroached,
form-
my lord.
my lord, let them file a detailed representation. If that has not been considered, my lord.
There's already
remedial
filed.
action by filing a PIL, my lord.
Annexer 2, page 20, my lord.
If any patta land has been taken, my lord,
Yes, my fertile land.
patta land, my
What-
lord, he is saying that he has given permission. My lord, this petition itself is not maintainable, my lord.
Heard Sri B. Hussain, learned counsel for the petitioners. Full stop. As for the facts projected, lands of the petitioners have been acquired for construction of a drain. Full stop.
Not acquired, my lord, he has given permission to her.
Not
Brought-
acquired.
Formally acquired,
It's not been
but
acquired.
measured the land and encroaching the land, started construction of big drain.
Permission given,
That the petitioners
pleading.
had allowed the authorities to construct a drain which has touched upon the patta lands of the
Yes, sir.
petitioners. Full stop. The petitioners have represented for constructing a public road also, and those representations are not taken into consideration. Para Sri N. Das, Learned State Council has however submitted
Para.
that the approach of the petitioners should be in the form of a public interest litigation. Full stop. Para, be that as it may, let notice be issued. Returnable by 4 weeks. PWD, anyone? Ms. A. Bhattakur, Learned Counsel, appearing on instruction of Sri Nayak. P. Nayak, standing counsel PWD for 1, 2, Three. 1 and 3. 2 and 4 and
I'll-
the State Council. Extra copies, para. Pendency shall not be a bar for consideration and disposal of the representations in accordance with law. Give me the extra copies.
Must
Please, your lord.
Yes.
But I am member of the bar of the Karimganj, my lord. I lodged an FIR while I went to visit the flood relief camp, my lord, last year on 5th of July, my lord. But I was assaulted by a group of people, my lord. And I lodged an FIR that was registered under 323, 324, 354, 307, 34 IPC. But when charge sheet was filed, I find that it was 341, 329, 352, 506 IPC, 34 IPC. My lord, in the meantime, notice has been issued to them. Someone has been issued. They have not appeared. Anyway, my lord, now, my lord, I have come before your lordship. Your lordship definitely asked me that after charge sheet, whether this will be possible to further investigation of the matter. But I got a judgment of 23 Supreme Court that when it said that victim has the fundamental right of fair investigation and fair trial. Therefore, filing of the charge sheet and framing of the charges cannot be an impediment in ordering further investigation, reinvestigation, de novo investigation if the facts so warrant. So, my lord, either I pray for notice or your lordship may dispose in the direction. I may approach the court, trial court also, that it should be reconsidered for reinvestigation.
Not reinvestigation, further investigation. my lord.
No, in Supreme Court, reinvestigation, further investigation.
See,
de novo
the trial court cannot go for a reinvestigation.
But,
Under subsection
unless you have ordered
73(8), it can be further investigation.
further
Reinvestigation can only be done by a 226 court or by the Supreme
further
Court under
investigation.
32. Those,
no.
those matters are settled.
Yes.
So, but after filing of charge sheet, as you have rightly,
This is the judgment, my lord. I am giving you.
name of the parties,
Name of the parties. Please, based on Jaldi.
Puja, what is it?
My lord, it is Anant Thakur Kharmose versus State of Maharashtra.
আছে নাকি extra copy আছে?
Sir.
Constitutional court for reinvestigation.
What do you say, Mr. Das?
This says, my lord, the order constitutional court may order further
No,
investigation
Yes, on this.
on my lord, circumstances that could be.
It's warranted.
It's up to him to prove that, my lord, that's reinvestigation or further investigation is.
Okay, heard 3 SC Biswas Learned Counsel for the petitioner. Full stop. It is the case of the petitioner that he had lodged an FIR resulting in Karimganj PS case number 451/2024, which was registered under section so and so. Full stop. However, after completion of the investigation, the charge sheet has been filed under section so and so. Full stop. The learned counsel has submitted that the investigation has not been fairly done and appropriate sections of law have not been mentioned in the charge sheet. He has also drawn the attention of this court to a decision of the Honorable Supreme Court in the case of Anant Thanur versus so and so, dated 24/2/2023 in criminal appeal number 13 of 2023 Silaba. In this regard, para, that notice be issued, returnable by 4 weeks.
6 weeks, my lord.
Okay, there are private respondents, 6 weeks. And thus, learned
1, 2, 3, 4.
State Council for 1, 2, 3, 4 extra copies 5, 6, 7, 8, 9, 10, 11, 12 registered post-petition steps within 2 working days.
Develop it.
Extra করে দিবি।
May I please your lordship, in this case, lordship, the executive magistrate, lordship, Kamrup, lordship, after proceeding under section 145 and 146, your lordship will find at page number 81. A final order has been passed directing the lordship, page number 81, lordship.
Yes.
On 21 to 2024, and the relevant parties, lordship, last paragraph, considering all the above fact and going through all the relevant documents, this court is satisfied to declare the possession of the
CRPC.
below scheduled land in question in favor of the petitioner. This order is made to hand over the possession of the disputed land over to the first party, lordship, and also direction has been made to the circle officer to deploy a lat mandal to vacate the disputed land and to hand over the possession over to the first party, that is petitioner. And OC Soigaon is directed to assist the circle officer during execution of this proceeding. Lordship, thereafter, lordship, the circle officer, lordship, several attempts has been made, lordship, lat mandal has been deployed. But due to Soigaon police, they have not initially cooperated, but subsequently, lordship, now Soigaon police has requested the circle officer to deploy the lat mandal. Your lordship will find at page number 97, lordship. After this direction also, lordship, the executive magistrate has passed on again a direction 26/6/2024.
It will be clear. It will be clear.
It will be said it a cooperation for an IP.
Circle officer.
This order has been passed under what provision of law?
Under section 145 of the CRPC. And
One-
because, and under section 146, lordship, attachment that can be made, and lordship, that is the procedure, lordship, procedure where dispute concerning land or water is likely to cause breach of peace, lordship. Because this
But
rule,
can you approach a writ court for execution? What remedy do you have? Writ court is not an executing court.
only my humble submission is that I'm, because this, earlier, lordship, the circle officer, lordship, requested the police to, lordship, deploy the sufficient numbers of police, and they have already deployed lat mandals, 2 lat mandals. Now, lordship, police has requested the circle officer to deploy the lat mandal for execution of the scene. Your lordship will find the, now the police has requested, lordship, after the circle officer wrote the letter to the.
কোর্টে কি করবে? কোর্টে কি করবে? এক্সিকিউশন কোর্টে কি করবে?
Execution কোর্টে কই আছে, the execution কৰিবলৈ দিয়ে।
নহয়, এটা রিট কোর্টে কি করবে?
না, root court এ just direction আছে দিবেন।
ফর এক্সিকিউশন।
Execution order can be complied with. Only because of non-cooperation between the lordship police and lordship circle officer.
File a complaint before the DC.
But how is the writ maintainable?
He can file a complaint before the DC and SP if someone is
Lordship,
not
in fact,
cooperating.
lordship, in page number 83, lordship, your lordship will find circle officer has written the letter to the SP, lordship.
But you write yourself. Since now you is complaint is against the circle officer.
And now, lordship, this police has written the letter to the circle officer, lordship, to deploy a lat mandal.
No, that was when? That was on which date?
Lordship, 15/5/2024.
15/5,
Lordship,
2024.
circle officer.
24 month.
24, that is what we are worried about. 1 year has passed.
24 my lord.
Thereafter, lordship, now, lordship, the police written 8/10/2024. Your lordship will find.
8/10.
Yes, your lordship.
2000
We are in 9/25.
11
And
months.
no,
11
thereafter
months.
again written, lordship, one letter, 16/11/2024. They are, lordship,
10
trying to, lordship, cooperate the circle officer, lordship.
No, these
But
are
now
things,
they have
145 proceedings, the
time is the essence. How fast you execute, you come after to your writ court after almost 10 months, 11 months. Number one. Number two, whether this is the remedy. Whether the writ court is the remedy. Approaching the writ court is the remedy.
Lordship, your lordship will find page number 93.
Ultimately, your concern is for execution of the order of the executive magistrate. How do you execute an order?
Lordship, status of the compliance of the order, that may be called for, lordship. Only that status, lordship, because why
Yes,
that
but
order has not
by
been
executive
executed,
magistrate.
lordship. Only that much is, lordship. Why that order has not been executed?
You wait till so long and you come out to the writ court. Yes, Mr. Das, we are not keen in entertaining this.
He can file a detailed representation before the SP and concerned.
No, SP is already concerned, lordship, because circle officer has written. to
Again,
Mr.
then it's better
And-
to write. to this way.
And
Heard
lordship, your
Sri
lordship
G.
will
Sharma,
find-
learned counsel for the petitioners who are aggrieved by the inaction to execute the orders dated 21/2/2024 and 26/6/2024 passed by the executive magistrate Kamrup. Full stop. It is also the case of the petitioners that the aforesaid aspect
Lordship, third order may be 12/9/2024.
12
12/9/2024, page number 93.
12/9/20.
24. Page number 93.
Where do you mention 12/9 in your prayer? How do you expand on the first day itself? Later on, what you will do, we do not know. Is there any mention of 12/9?
In the 12/9 order, lordship, it was that.
Where have you mentioned 12/9 in your prayer? Is there any mention even? Executive Minister Kamrup in case number 51 within 51 would upward M, huh? Case 22 side about 2020. Full stop. Three. And thus Learned State Council has, however, raised the issue of maintainability of approaching a writ court for execution of orders passed by the executive magistrate in a proceeding under section 145 of the CRPC bracket में corresponding to so DNSS. Let notice be issued returnable by that party is not respondent.
Lordship, I have no grievance against him, lordship. Only my grievance is to comply that order, lordship.
He will not be affected.
I will not be affected, lordship.
He will not be affected.
Lordship, I may be allowed to.
You should make him a party. He is the necessary party. This order which you are prayed for will
Without
affect
him,
his
my lord,
rights.
no effective order can also be passed, my lord. Because the order is says of
Three.
something civil cases pending.
You accept for all, Mr. Das?
I'll be 2, 3, 4, 5, 6, 7.
One, Pierre Mohanta, 1, 2, 3, 4, 5, 6, 7. 7, sir. 3, Sharma prays for and is granted liberty to file IA for implement of parties. Para. Maintainability of this petition is, however, kept open.
Notice has not been issued, no, my lord.
Good notice issued. Notice 6 weeks.
Lordship,
Extra copies.
instruction may be called for because that.
What instructions were finding difficulty in your maintainability? It is 4 weeks for you. 4 weeks, not 6 weeks. Yes, next.
Highly applied.
Notice kolu to ami. Yes,
May
13, Mr. Sharma.
Made with your lordship.
Here in the respondent number 3, that is district commissioner has allotted a model Anganwadi center.
Before my learned friend starts, most probably it's a bench 3 matter,
Three matter.
whether your lordships will,
5 QL.
it's a bench 3 matter, lordship. I'm,
Bahir to 5 likes a better. 10189 has been given, bench 5 has been given. Right, bench 5.
the Anganwadi Central Lordship, I know it's a.
What is your grievance, Anganwadi Center?
Grievance is that, although allotted lordship, the principal in the place of old Anganwadi center, which was attached with the, lordship, that was attached with 37 nong Boiragi LP school. But now, a kitchen has been allotted to the LP school, lordship. In the place of this Anganwadi center, lordship, they are constructing the kitchen, lordship.
It's a dispute for a kitchen.
Not for a kitchen, lordship, the whole scheme will be taken out if
Who
the
is
place
it?
is not.
Who is the petitioner, lordship?
Who are you?
Lordship, I am a local person resident, lordship, of board.
Doesn't have that locus.
Then notice may be issued.
You come, let the appropriate person come, not at your behest. Heard. 3 S.J. Sharma, learned counsel for the petitioner. Also heard. 3 H. Sharma, learned addition senior advocate. And Miss Fukan,
S4, lordship.
S. Kumar for
Respondent number 5, lordship.
5. Standing counsel education.
Eviction, lordship.
Okay, correspondent 5. Para. The petitioner claims to be a local resident of Bor Boiragi Gaon and a social worker. Full stop. The villagers of the village had submitted a representation to the CDPO Bozali for establishment of a model Anganwadi center in place of the old 73 number Anganwadi center, which is attached to the 37 number Boiragi Lower Primary School. Full stop. The said request was exceeded and a notification was issued for establishment of an Anganwadi level construction committee for construction of the model Anganwadi center. Full stop. In the said list, the center of concern was again serial number 16. Full stop. However, the respondent number 7, who is the headmaster of the school, without consultation with the school's managing committee, has decided to construct the new sanctioned kitchen of the Boiragi LP school in front of the 73 number Boiragi Anganwadi center. Full stop. The petition, it is the contention of the petitioner that the aforesaid decision would not be in the interest of public and would also damage the school's infrastructure and healthy environment. Para. Sri H. Sharma, the learned state counsel, has however raised the issue of locus of making the present challenge. Full stop. He has submitted that the petitioner cannot raise the said grievance as none of his rights have been infringed by any action. Full stop. He has also defended the action of the respondents by submitting that the same has been taken in the greater interest of the public. Para, the aforesaid submission is also endorsed by Ms. Kaur, the learned standing counsel, Education Department. Para, after consideration of the facts and circumstances and the submissions advanced, this court is of the view that without even going to the grounds of challenge, the locus of the petitioner to institute the present challenge would be a stumbling block to maintain the present writ petition. Full stop. This in the this court, there is no materials on record to show that any rights of the petitioner has been infringed by the action involved, full stop. Para, in view of the above, this writ petition is dismissed, full stop. It is however observed that the dismissal is only on the ground of locus and no observations have been made on the inter se merits of the case. Obliged. No opinion has been expressed. No opinion has been expressed. 1-4.
Yes, there is a caveat also. There is a caveat on behalf of respondent number 8, but it is not shown in the cost list.
Hertz v. S. Islam Learned Council, who has lost the caveat for a proceeding of the meeting dated 10/7/2025 of the Doipam Gao Panchayat in the district of Darang. Para, the caveator would be heard in the event this court proposes to pass any interim order. Para, caveat stands is disposed of. Yes.
What happened in this case, my lord? First meeting 21/6/2025 was deferred, my lord, without any reason. Second first meeting 2/7/2025.
First was 21/5, 21/6.
21/6, my lord, deferred without any reason, my lord. Secondly, my lord, first meeting 2/7/2025, on that day, my lord, only 4 ward member was administered.
Second when? 26/6.
And second one 2/7/2025.
Second meeting.
Yes.
Deferred meeting.
At the deferred is, my lord, 21/6.
That is it. Then deferred meeting held on to 2/7.
Yes, 2/7.
Yes.
And then, my lord, next meeting, next first meeting was held on 10/7/2025.
What happened on 2/7?
Deferred.
2/7 again deferred.
Again.
Again deferred.
Yes.
Then
And, my lord, on that day, my lord, 10/7/2025, administered the oath, my lord, and signature took in the proceeding book. And the petitioner, six petitioners, my lord, they are supported petitioner number 1 as a president and petitioner number 2 as a vice president, and as subsequently, my lord, election was held, my lord. In the election, my lord, the 6 petitioners casted their vote in favor of the petitioner number 1 and 2. And 4 other respondents, my lord, their casted vote in favor of the respondent number 8 and 9, my lord. But the respondent number 4, in a illegal manner, my lord, declared the respondent number 8 as a president, my lord, who has secured only 4 votes, my lord. That's my grievance, my lord. I have immediately submitted application on, my lord, 10/7/2025 before the deputy commissioner, and subsequently on, my lord, 28/7/2025. Also submitted application under section 11. Deputy commissioner is the competent authority. But yet to be disposed of my application, my lord.
yes, if 6 are there, how do you get elected?
Yes.
No, yes. This is sacred ballot, your lordship.
Secret.
Lordship.
So there 6 are before this court.
Yes, before this court.
They'll not come before this court.
Yes.
They, at the time of election, there is no complaint, your lord. They have casted their votes in my favor, your lord. I am for respondent. Now they have come. Your lord.
If the
Because
casted,
there is-
why the petitioners are before this honorable court?
Something is there.
It is for you to explain.
Yes, my lord. He immediately submitted application on the very day, my lord.
You change.
Yes.
Stand-
No, my lord. No, my
Something
lord.
did not work out.
6 petitioners, my lord, is still before this honorable court.
Huh?
As on today, my lord.
Some equation did not work out with the new president. So you came to this side. But if 6 are before this court, how do you get elected?
At the casting vote, your lordship, they, the secretary, your lordship call for the record, then you will verify. Your
What about 111? Your appeal is pending.
My lord.
Your appeal is pending.
Yes, my lord. The application is
Considered it
pending.
appeal. When was it done? When was it done? Let him be satisfied if the appeal
Section 11.
takes care of his grievance. Matter ends
Section
there.
11. Section
If he is not, then he can approach this court. But matter of concern, 6 are before this court. They say that they have not voted for him. How does he get elected?
Not only this Panchayat, my lord. Earlier, before this honorable, two Gao Panchayat, my lord, I have appeared with this court, my lord. Same thing happened, my lord. Entire Dorang district.
In Darang district.
Something is wrong with the ballot papers. It
No, but,
changes.
my lord, more particularly in the core district, my lord, Dolga core district, my lord, the circle officer and the core district additional commissioner, my lord, there. Something there. Goradar Gaon Panchayat,
Okay.
my lord, Baligaon Gaon Panchayat also something happened, my lord.
Third, this is Hasina Begum. Third, Sri A.M. Ahmed, learned counsel for the petitioners. Full stop. It is the case of the petitioners who are 6 in numbers, that they are the elected ward members of the 74 number Doipam Gaon Panchayat in the district of Darang. Full stop. The first meeting was scheduled on 21/6/2025, which was deferred and finally held on 10/7/2025, when the petitioners, along with the private respondents, had taken oaths. The petitioners have specifically contended that in the election for the post of president and vice president, they had selected the respondent numbers 8 and 9. Full stop. However, when the results were declared, it was the they had selected the petition number 1 and 2 as president and vice president. However, when the results were declared, it was found that the respondent number 8 and 9 were found to be elected as the president and vice president. Full stop. It is submitted that when the majority of the elected members who are the petitioners in the instant case had voted for the petition numbers 1 and 2, the said respondent numbers 8 and 9 could not have been elected. Full stop. It is also submitted that in the meantime, the petitioners have filed
Page 44.
representation under section 111
11.
of the
Assam Panchayat Act.
11 of the Assam Panchayat before the district commissioner
Deputy Court.
Yes.
on
District
On, my lord,
28/7.
28/7 and 10/7.
on 28th representations paper 28/7 and 10/7
10.
2025, which have not been taken into consideration. Para, let notice be issued returnable by 4 weeks. 3 Doctor for
My lord, I am for 1, 3, 6 and 7.
1, 3, 6 and 7. 2, 4, 5. Then as Islam for
Respondent 8 units.
8 only.
8
8. 8 extra copies. 9, 10 and 11 by registered post with AD. Steps within 2 working days.
A Dusty service may be allowed.
Additional dusty, 9, 10 and 11. We give a date then. Today is 5th. When can you have? We can have it on, last week will be difficult. Week from 22nd to 26th will be difficult. We can have it on the reopening 14th. 14th of October. But before 14th, you have to file the affidavit of Dusty.
Yes.
Okay. 14th of October. Date, Dusty and affidavit before the said date. Sri Islam, the learned counsel for the respondent number 8, who has filed a caveat, has submitted that the elections were held by secret ballot. And there was no illegality.
Yes, my lord, attendance of the retribution shall not be bar to dispose of my.
Yes. Penalty of the writ petition shall not be a bar for consideration and disposal of the representations dated so and so and so.
Oblige.
Well, my assessment was completed, my lord. After examination of the books of accounts and documents,
Yes.
140 assessment, thereafter, my lord, a notice was issued to me which was also found at page 144. My lord, I'm sorry, my lord, it is 144. my lord.
Assessment, you say assessment was complete.
My lord,
You said the assessment was complete.
my lord, assessment was completed, thereafter a notice was issued to.
Yes.
Where it says, my lord, you also can see at page 144. As per so-and-so information available on portal of the SSC, had unaccounted income of rupees 2 crore 42 lakhs. The above had not been reflected in return of income for the assessment year so-and-so. Now I submitted reply at page 145, my lord. Because it says only, my lord, 2 lakh crore 42 lakhs. No name, nothing. So I said, kindly give me the details. You also see page 146.
Yes.
And also we said that we have no income like such. Now again at page 147, you also can see the notice on 148 was issued. When you also can you take the trouble what it says, my lord?
Yes.
I have information that a search was so against under section 132 in your case or in the case of the person in respect of which you are accessible under the act on the so-and-so. Now in my case, no search was conducted. There is no such case. Now he said, I am satisfied with the approval of the Principal Commissioner of Income Tax that the books of accounts of opportunity so-and-so under section 132 Act, Kailash Kumar Patwari pertains to or information obtained therein needs the person so-and-so. This notice issued after considering the so-and-so. Now, this notice has been issued, my lord, in respect of some other person. And now the regions you also see what he's saying. Earlier it was 2 crore 42 lakhs. I said the game, give the details. Now you'll also see 151.
Yes.
The second paragraph, my lord.
Yes.
Shri Kailash Patwari has facilitated loan of rupees 82 lakh 50,000 to so-and-so through various companies, HUF and individuals. The companies and the business entities are controlled by so-and-so, which the are not have been state business. Now earlier it was 2 crore 42 lakhs. I said that give the details. Now details, my lord, now they are saying 82 50,000. And what they are saying, my lord, that through various companies, HUF and persons. Now, who are the HUF? Who are the persons who have given me loan? Because I specifically said in the petition that I have not received a single paisa loan during the year. In fact, I give the loan to somebody else. And in my assessment, which was completed, it was said, my lord, because you are giving interest-free loan to somebody, the interest will be chargeable. I preferred an appeal. Appeal was dismissed. I went in tribunal. Tribunal said that no interest will be chargeable. Now he is saying, my lord, earlier 2,42,000. Now 82,500. And secondly, my lord, section 148A of the Income Tax Act. Well, you also make a see, my lord, section 148A. At page, my lord, 16. It was newly inserted, my lord.
Yes.
It says, my lord, the assessing officer shall, before issuing any notice under section 148,
Yes.
shall conduct an inquiry if required with the prior approval of concerned authority with respect to the information which suggests that income chargeable to tax has escaped assessment, provide an opportunity of being heard to the SSC by serving upon him to notice to so cause within such time as to why, as may be specified in the notice, not being 7 days, but not exceeding 30 days from the date of such notice is issued, or such time as may be stated by him on the basis of the application in his behalf, as to why notice in the section 148 should not be issued on the basis of information. Thereafter, my lord, C, consider the reply of the SSC furnished, if any, in response to so called notice referring so-and-so, then decides on the basis of the materials available on record, including the reply of the SSC, whether or not it is a fit case to issue notice in the section 148 by passing a order with the prior approval of the specified authority. Now, nothing, no 148 notice, no opportunity to give a reply, and no order has been passed rejecting my application, which is a mandatory precondition for issuance of notice under 148. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . .
Yes, what do you say, Mr. Chetty?
Lordship, it's only a notice, my lord, for initiating a proceeding under section 147. Lordship, in fact, the section 148A, Lordship, which has been referred to, my lord, that itself has said, my lord, there are certain provisions, my lord, where this section shall not be applied in certain cases, my lord. And subsection C, Lordship, your Lordship may see page 18 of the petition. That is the proviso. It says the assessing officer is satisfied with prior approval of the principal commissioner or commissioner that any books of account or documents seized in a search under section 132 or requisition under section 132A, in case of any other person on or after the first day of April 2021 pertains to any information contains therein. So, my lord, that is not always a mandatory.
But he had asked for the details.
Lordship.
He had asked for the details.
Lordship.
In person to the notice at page 144, he had asked for the details.
My lord.
And there appears to be a major inconsistency with the
Lordship.
amount involved.
My
2
lord.
crore 42 lakhs became 82 something.
Lordship.
You will issue notice at this stage.
Lord.
Okay. Third, Dr. A. Saraf, learned senior counsel for the petitioner, who is aggrieved by the proceeding initiated by the notice dated 30/8/2024 by the Deputy Commissioner Income Tax, / Assistant Commissioner of Income Tax, Circle 1, Guwahati. Full stop. The said notice has been issued under section 148 of the Income Tax Act 1961. Full stop. It is contended that as the notice was vague, the petitioner had asked for the details in its response furnished, full stop. However, no such details were given, and on the other hand, in the subsequent communication, it has been there. It appears that there is a marked inconsistency, both with the contents of the notice as well as the amount involved. The Learned Senior Counsel has also drawn the attention of this court to section 148A of the Income Tax Act and has submitted that the said provision, which has been brought in the statute book vide an amendment on 1/4/2024, is mainly to give certain safeguards to an assessee, and those have been violated. Full stop. Let notice be issued, returnable by 6 weeks. As Chetia, senior standing counsel,
Lordship.
Income Tax Department accept notice on behalf of all the respondents. Para
For 2 and 3, Lordship.
1, CGC. Okay. CGC. Madam will be taking CGC. CGC, anyone?
We'll serve on the DGI, no?
Mr. R.K.D. Chaudhary is there in the court. A Gayan. Gayan is there. Miss A Gayan for 1. You will serve upon Gayan. Then 2, 3 by Chetia. 3, Dr. Saraf, the Learned Counsel prays for an interim order. Sarah, after considering the facts and circumstances, it is provided that till the returnable date, no coercive action be taken against the petitioner, qua the notice dated 30/8/2024.
In this case, this will be further proceeding. The coercive measures at present will not come. Further proceeding because they are going to assess and all those. And
For that, we should not have a blanket order.
Because the Calcutta discount case in the yesterday, the appeal was also preferred. Therein also, 148 was there. There also similar type of order has been passed. That no final orders will be passed.
Yes.
Lordship may allow the proceeding to continue, my lord, subject to.
It is provided there will be no bar in the continuation of the proceeding, no final orders be passed without taking leave of this court.
Okay.
Till the returnable date, huh? Returnable by 4 weeks.
Lot, oblige.
Not your lordship, kindly see page 18.
Yes, yes, Mr. Gogoi.
My lord, before that, my lord, this petition is not maintainable. Because means the entity before lordship is though it's a budget committee, but there are no registration papers with this, my lord. It's a subtle law. The body has to be registered. Only they can move the high court.
My lord, let them bring the, my lord, their objection by way of affidavit.
No, my lord.
Regarding maintainability of the
This is
petition,
the-
there are decisions.
Just a minute,
It's
Mr.
gone
Gogoi.
that way, my lord.
Just a minute.
If you
Mr.
want
Gogoi.
Supreme Court, I remember, my lord.
And the second petitioner
And
poses
this is
himself to be the
this is a
secretary.
notice has been issued for, my lord, eviction from the forest land. So let me place the case, my lord, page 18, your lordship will kindly see. Against eviction notice, that is not on the ground that they are unregistered Masjid committee, on the ground that they are occupying forest land.
Yes.
Page 18, my lord, this was a notice in the year 1996. The original is at page 20. 1996, the possession was handed over as per direction of the sub-divisional officer by the cycle officer to the Masjid committee. So since 96, this Masjid is operating, my lord, and area of land is 4 kathas. Notice was issued by the civil authorities, page 25. My lord, before that, my lord, page 22, your lordship will kindly see. That 81, my lord, that is the.
No, your primary contention is that the land over which you are standing
Yes.
is not forest land.
Is not a forest land.
You take instructions on
Yes,
that?
Well, I have taken instruction. And my lord, the DFO has also agreed. If they are so agree, we will conduct a joint verification.
Yes.
With the revenue.
See,
That comes in.
See, Mr. Das, if it is forest land, we will have to take a different view. If it is not forest land, then you may have a case.
What I am showing, my lord,
Yes.
page 22, your lordship will kindly see.
22.
Yes,
Yes.
sorry, my lord.
The map,
25, 25.
25.
This was a notice issued by the Revenue Authority in the year 2010. Notice for eviction as per the order of the Supreme Court, etc. Then we have shown, my lord, we have shown that we are in occupation since 1996. The
What happened?
representation was filed. It stopped. Then thereafter, we filed an application for allotment of land, page 27, Vasundhara. That is pending. Now this notice has been issued by page 28, saying that you are occupying a forest land. So forest land, my lord, I'll just bring to your lordship notice that the division bench order of this court, even for forest land, we have given a representation saying that we are in occupation since 1996.
Okay, you take instructions. A short notice will.
Meantime, my lord, your lordship-
Will issue a short notice. Heard Sri D.D. Das, Learned Senior Counsel, assisted by Sri Forecaster
Yes, that's
for the petitioners. The petitioners are aggrieved by a notice dated 22/8/2025 of eviction. Full stop. It is the case of the petitioners that the land in question was handed over possession in the year 1996, and on an earlier occasion in the year 2010, a notice for eviction, though issued, was not proceeded with. Full stop. It is also the case of the petitioners that they have filed application under the Vasundhara scheme for allotment of the land. Full stop. Para. Sri D. Gogoi,
Allotment
Learned
of patta,
Standing
mein.
Council
See,
of the Forest Department has however raised an objection, a preliminary objection on the maintainability of the petition by submitting that the petition number 1 is not a registered society. Full stop. Para. He has also submitted that the area being forest land, the petition, no enforcement can be permitted under any circumstances. Para. Let notice be issued, returnable by 4 weeks. 3. Revenue. Arbor Pujari 1 and
Only 1, 2 and 3, my lord, my colleague will be.
2 and 3. H. Sharma. additions anyway. Then Gogoi for 4,
My lord,
5 and 6.
4, 5, 6 minutes.
Extra copies be served. Full stop, para.
Opening.
Pendency shall not be a bar for a demarcation exercise
Right.
to be conducted by the authorities by taking into in the presence of the petitioners or their representative. Full stop. It is provided that till such demarcation is done, comma, status quo as in today be maintained.
This is what the apex
My
court
lord,
has done.
my lord, I will pray for a fixed date and my lord will indicate the authorities will be involved, my lords.
We have already said.
The
Lordship
revenues
control.
and the forest.
The revenue authority as well as the forest.
My lords.
We'll give a date, Mr. Gogoi.
Can it be prior to vacation, my lord, with all respect, my lord?
Today is what?
Today's feed, my lord, can it be on 22nd, my lord? 22nd, my lord, with all.
We can try on 22nd.
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 Reasonable date 22nd.
But
Extra,
I have-
please, Mr. Purkasta give extra copies.
My lord, I endorse the submission of read petition is not maintainable. My lord, the maintainability may be kept open, my lord. With all.
There are 2 other petitioners.
No,
My
two
lord,
other
your lordship will
petitioners-
kindly see page
There are 2
44.
and 3.
No, two other, there is not a single averment that they are conducting worship in that, my lord, to.
We are not on 1.
No, one,
For
my
2
lord,
and 3.
2 says I'm secretary of that organization.
2 and 3 are by parties by name, not by secretary or by president.
One cannot go.
Three, there is no issue.
They are,
No, registration, non-registration, those are very technical issues. You know, we are on a writ court. You come up on merits, we'll.
definitely, my lord, but here, my lord.
No,
there
this is not a
single-
case where registered body is not come or come. That is not the issue.
Absolutely, my lord. Even
Some
if we
persons have
forgo-
come, we are trying to examine their case. If you find that there is no merits, we'll dismiss it. Nothing else there. Very good. Our board judge has endorsed the submission.
Oh, let's go.
Yes, Dr. Sir.
The issue raised in the preliminary application is as to whether, my lord, under the Finance Act 1994, the commissioner has any power to condone the delay beyond what is prescribed under the act. You'll also see kindly see, my lord, page 11. Page 11, my lord. Section 85 of the Finance Act 1994. And you'll also kindly skip over and come to, my lord, page 12. 3A.
Yes.
An appeal shall be presented within 2 months from the date of receipt of the decision or order of such adjudicating author made on or after the Finance Bill 2012 received the assent of the President relating to the service tax interest penalty under this act. So within 2 months, the appeal has to be filed. And subsequently, my lord, provided that the Commissioner of Central Excise Appeals may, if satisfied, that the appellant was prevented by sufficient cause from presenting the appeal within the aforesaid period of 2 months, allow it to be presented within a further period of 1 month. The issue which arises for consideration before also with that, whether this explicitly or impliedly excludes the operation of section 29(2) of the limitation and litigation. Now, similar issue came up for the apex court while considering the provisions of the Arbitration Act,
34.
section 34. You'll also see page 16, my lord.
16.
16, my lord.
Yes.
I'll take your lordship to.
That we know about. Yes.
Lord, the word was that not, but not thereafter. You'll also see proviso, my lord, not thereafter. The apex court in the judgment, my lord, held that because the word not thereafter is there, and as such, it is explicitly included. The apex court also made it clear, my lord, that if the word but not thereafter would not have been there, then the things would have been different. You'll also see paragraph 8, my lord.
Now, after popular construction, there are many other case laws on 34 limitation.
Well, limitation act, this judgment has not been executed. This will remain the same.
There are.
This judgment, my lord, so far as the applicability of the limitation act is concerned, this has not changed. Now, my submission for lordship that, my lord, I preferred an appeal before the Commissioner appeals. And I gave that I was suffering from severe ailments, and I gave all the medical certificates also. Now, the Commissioner appeals has dismissed the appeal on the ground only of limitation. My prayer, my lord, that this honorable court also under 226 has the power to condone the delay.
No, limitation act concern.
I'll give the act, my lord.
No.
Twenty-nine two, my lord.
Just a minute, please.
Madras also apply, you know. Trust me. That's my ground of place. Now, the divergent view has been taken by the various high courts under the GST regime, my lord.
Now this, what is this kind of proceeding?
My lord.
Where you are trying to apply the limitation act, what is this kind of proceeding?
Well, this is appeal, my lord, before the Commissioner appeals.
The limitation act is applicable.
My lord, our submission is that appealable, and the Calcutta High Court also, my lord, in the number of judgments has held that under GST law, similar provision is there, that limitation act will be applicable, whereas, my lord, the Delhi and the Allahabad High Court has held that, my lord, limitation act
No,
will
if
not
you
be
are
applicable.
seeking the provisions of section 4, it applies to suit, appeal or application.
My lord. But
Now-
29.2, my lord, 29.2
No,
says.
29.2 is a general provision. How do you construe? How do you construe? Now, we are on the applicability of the limitation act so far as an appeal filed under this particular act of, Finance Act of 1994.
Because I was saying, the 4 to 24 limitation act as such is applicable, but 29.2 says that if the special act had not explicitly excluded 4 to 24, whatever provisions are there, that will be applicable. And basing on that, the Calcutta High Court also in a number of decisions has held that this will be applicable for the limitation act. Under the, because the normal cost limitation act is only for courts and Miller only. But the 4 to 24, if the special act has not excluded, then it will be applicable. And these are the decisions of the Calcutta High Court, my lord.
No, we have understood your submission. You are trying to distinguish between 34 of the Arbitration Act and this provision. 34 says there is a further qualification.
Not thereafter.
And not thereafter. That qualification is not here in so far as section 85, proviso 3, subsection 3A is concerned.
Right.
So if the provision is not there, it's a special statute. But in that case, you take your submission will be based on section 4, that you still have a power to condone.
Section 5, my lord, the power of condonation 4 to 24.
Yes.
Now 5, I will say that section 5 of the Limitation Act will be applicable.
Yes, what do you say?
Lordship here, Lordship page 70. There is a-
70.
Lordship, paragraph 9.3.
Seven zero.
70.
Yes,
Paragraph 9.3.
9.3.
In this regard, the Honorable Supreme Court, in case of Asset Singh Enterprise versus Commissioner of Central Excise, so and so, held as follows. The Commissioner of Central Excise appeals
as also.
Oh,
that-
this is Supreme Court.
Yes, Lord.
What is your response to this, Mr. Dr. Saraf?
No, the response to this is that, Lord, in 2019 again, the Supreme Court considered this judgment also and said this is on the basis of the scheme of the central exciser.
Where, which case?
There is superintending engineer, my lord, which has been considered by the, my lord,
Can you place that superintending engineer? Yes,
superintending engineer.
this Messrs. Singh Enterprise has been considered.
Well, it was there, my lord.
Which paragraph?
I have submitted, my lord. At page 713. Yes, ma'am. Page 713, my lord.
713.
My lord. 713 and. No, 712, no, 712. In the pages. 32.
4. Punjab favors.
Let me check single enterprise.
713.
113G. Seven one three G.
Yes, we have seen that. Singh Enterprises.
My lord. And after consideration of that, my lord, that was said that this was on a provision of the,
Okay, we'll examine this. We'll examine this.
and because the diverging view, my lord, of the various high courts.
Heard. Dr. A. Sharaf, Learned Counsel for the petitioner who is aggrieved by an order dated 25/3/2022 passed by the Assistant Commissioner CGST Jorhat Division, whereby a demand of service tax of rupees 25,30,741 has been confirmed along with interest, cess and penalty. Full stop. Please have your seat.
Well,
The grievance also is extended to the subsequent order dated 24/7/2025 passed by the Commissioner Appeals, Commissioner Within Bracket Appeals, CGST, Central Excise, whereby the appeal of the petitioner has been dismissed on the ground of limitation. Full stop. The Learned Senior Counsel has submitted that under Section 85 of the Finance Act of 1994, there is a provision for appeal, and under subsection 3A capital, a period of limitation has been prescribed as 2 months with a proviso for further extension by 1 month. Full stop. It is submitted that there being no further qualification in the language of the statute, comma, the said proviso has to be interpreted liberally, read with Section 5 of the Limitation Act. Full stop. He has also drawn the attention of this court to the observations made by the appellate authority, which has taken into consideration the case of the Honorable Supreme Court of seeing something, of Singh Enterprise. No, is it Singh Enterprise? Of Singh Enterprise, पूरा नाम लिख लीजिए, हाँ? Reported in 2008, 3 SCC 70, and has submitted that in the subsequent decision of the Honorable Supreme Court, in the case of superintending engineer ... reported in 2020, 17 SCC 692, the provision has been explained. What's the para? Let notice be issued, returnable by 4 weeks, 3 S. Kyle, the learned Senior Standing Counsel CGST accepts notice on behalf of respondent numbers 1, 2, and 3.
2 and 3 books.
One MDAS.
MDAS.
MDAS on behalf of S committee, CGC for 1, 2 and 3 SC Kyle Standing Counsel, Senior Standing Counsel 2 and 3. SBI and Axis Bank help to serve. Extra copies. 4 and 5 registered post with ED. Free, Dr. Saraf, the learned senior counsel prays for an interim order. Sarah, considering the facts and circumstances, it is directed that till the returnable date, no further action be taken pursuant to the impugned order dated 24/7/2025, passed by the Commissioner Appeals. No, initial order is by whom?
By initial or by the assistant commissioner?
We put the initial order. No further action be taken pursuant to the order dated 25/3/2022, passed by the Assistant Commissioner, CGST, Jorhat Division.
No, if you also further coercive measures will be better,
We have said no action.
but
None.
because the no action, they have already the commissioner has already dismissed the appeal.
No further action. No further action. No, therefore, we have referred to the primary order.
My
Staying the appellate order will not give you anything.
I'm obliged.
Mr. Kyle will require assistance this part.
Not six.
Section 5 applicability.
Not six.
Whether further qualification is required and not thereafter would meet something else.
The legal issue, not the.
Vis-a-vis that section 34 of the Arbitration
No.
Act. It's a special statute.
Yes, not six.
And also, the lordship has to consider the different decisions of the High Court.
We will do it.
Fine.
20. So Das,
My lord, in this case, my lord, petitioners, my lord, purchase a plot of land, my lord, measuring 2 plots of land, 9 biga, 2 katha, 10 lessa, in the year, my lord, 1969, my lord. In that land, my lord, they were also mutated in the record, my lord. One Kasapatta also given, subsequently mutated. But what has happened actually, my lord, some of the persons, my lord, inserted there because those are the person who has sold the land to us. my
some
lord.
persons, what happened? Some persons?
Some persons, my lord, legal here of the my lord, seller, my lord,
Vendor.
vendor, my lord. They were, my lord, inserted after the death of their father, my lord.
In the mutation, in the Jamamandi.
Yes, my lord.
Okay.
Prior to our mutation record, etc.
Okay.
Subsequently, we
Your purchase was by a valid registered deed.
registered it, sell it, my lord. That's why, my lord, we are time and again opposing that why they are were inserted there, my lord. Kindly peruse your lordship, last, my lord, one annexer, my lord, page 58, my lord, translated copy, local vernacular, my lord, page 60, my lord. We pray for deletion of their name. But in spite of that.
No, they have registered a case for deleting your name.
No. Initially, my lord, we purchased the land. My lord, we pray for mutation of our name, demarcation, etc. In the meantime, what is after the death of their father?
Miss Case 28 of 2025 has been instituted by the private respondents.
Yes, my lord.
For deletion of your name.
Our name.
From the
Last,
Jamabandi.
this is the present status.
You have filed objection.
Objection.
No orders have been passed.
No order.
What is your grievance?
Now my grievance is that they are trying to, my lord, delete our names, my lord. In
Let
spite of our-
them delete. If they delete, it will come to us. Or not to us, to the appellate authority.
Because
How do
my
you
lord,
preempt
take
an
my lord,
authority?
what is happened, my lord, for allotment of land, adjustment of land, my lord, thermal project is going on there, my lord. Our land has been inserted here in the kindly peruse your lordship, page 15, my lord, page 78. Kindly see top of the here, my lord.
78.
Yes, my lord, 78. Last annexer. Individual allotment settlement proposal of Bilasipara in the heading of Bilasipara Port District received from Sapor Revenue Circle to be placed in the CDLAC. And that means as Sapor meeting held on 22/7/25 at 11 AM in the conference hall of CD's office Bilasipara. Our plots of land, my lord, inserted here, page 79. Page 79, next page, from serial number 29 to my lord 48. Dag number is, you can kindly see your lordship, 1 and 5, patta number 11. Starts from serial number 29. That means they are going to allot the land to them now. 115, 11. And next,
So thus your grievance is against a notice of 7/8/2025
yes,
issued in miscase 28 of
yes, my
2025
lord. That is
instituted by the first party.
not to the,
How
our
do
name,
you, how do you stay the proceeding?
yes.
How do you stay the proceeding?
Oh, my lord, ma'am, because my lord, what has happened, my lord, actually, in view of the earlier, my lord, all papers, my
You
lord, they,
show your cause before the authorities, their application will be dismissed. Why do you want to stay the proceedings?
filed the objection in
objection, that is, already, we have already objection.
There is no
But
order.
they are- Now, unless you bring one order from the honorable court, we cannot, my lord, because their names were already inserted there in the record. They are saying, my lord, because kindly peruse, let's say,
Mr. Das, your submissions are not consistent. It is their application to delete your names. That means your names are there in the Jamabandi.
yes, my lord,
Now you have filed your objections.
objection.
No final orders have been passed by the
Pass.
authority.
Pass.
Now in the meantime, it appears that the land would be acquired for some power project.
Yes.
Your land, your name is already there in the records.
Record.
So what is the
But they are,
prejudice you are suffering?
that land has been going to allot those persons, my lord, private respondent.
Let it be done. It has not been done. Don't
yes.
you think it's premature?
Their names are already, my lord, in the meeting held 27/5. Kindly peruse, see your lordship, page
Don't think
22,
it's a case.
7/25, meeting held.
Let orders be passed by the, we cannot stay the proceedings. You have filed your objection. We cannot preempt the officer to take a decision.
A notice may go, my lord.
Notice for what?
Otherwise, my lord, if no notice up them, my lord, the private respondent and the government also, my lord, then they may, my lord, finalize the process, my lord, allotting the land to those private respondent.
Let the order be passed by the authority in miscase 28 of 2025. Your avenues for challenging an order, if it is against you, it's always there. Third,
But from 22 onwards, my lord, we are opposing, my lord. These applications, all applications, they had refused to dispose of my representation.
Result 3H, thus learned counsel for the petitioners. First of it is the case of the petitioners that they had purchased 2 plots of land in the year 1969, wide registered sale deeds, and their names were recorded in the Jamabandi. Full stop. However, the private respondent has, how many private respondents are there?
17, my lord.
Huh? 17.
17, my lord.
Our respondents have
8
inserted
to,
their
my
names
lord, 8 to 24.
in connivance with some authority, and thereafter have filed miscase 28 of 2025 for striking out the names of the petitioners from the records of right. Full stop. The petitioners claim to have filed objection and is apprehending that their names would be struck off. Full stop. Para. Let notice be issued, returnable by 4 weeks, 6 weeks. 3. Revenue PR Mohanto 1 and 2 is thus 3, 4, 5, 6, 7. Extra copies 8 to 24 is third post with AD. Para. Penancy shall not be a bar for the authority to pass final orders in the miscase so and so, which however has to be done strictly in accordance with law.
Yes, my lord. Avlas, my lord.
Miscase 78 kuch hai na, dekh लीजिए.
GST cancellation is covered by lordship order, my lord. Item 41 is similar, my lord. Item 41 supplementary.
Lordship. Make the corrections, sir.
My lord.
R.S. Mishra, KGN on behalf of ST Cal, Senior Standing Counsel, CGST. Okay. Covered, huh? Both. This and 40?
Lordship.
Item
41, my lord.
41.
Obliging.
41, 21 and 41, okay, dispose of. Thirty-nine, Mr. Das, yesterday we had taken up your matter.
Yes, Lordship. I have served the copy they have.
Yes,
entered it.
State Bank.
Yes.
Yes, what do you say?
In fact, the writ petition has been filed obstructively. In fact, to stall the Your Honor, taking of a physical possession of the mortgage property. The order was passed by the Your Honor learned recovery officer, that is at page Your Honor 24, Your Honor. If the petition is aggrieved, Lordship, by the order, there's a statutory remedy of Your Honor, appeal, Your Honor, before the learned presiding officer.
No, he is praying for some time. He's suffering from some ailment, serious ailment.
Yes,
That is the reason.
Lordship, in fact, the original judgment was passed in the year 2000.
That we have understood.
Yes.
Then there was a failure, then again he started to repay.
Yes.
Then he has fallen, he has
Yes,
been struck with some serious ailment. That is the only reason. Otherwise, DRT matters, we are not, we do
Lordship,
not
in fact,
interfere.
the OTS proposal, what he had submitted recently, that was also Lordship rejected, and it was intimated to the petitioner, Lordship, on one line.
Day after.
That's what you propose. See,
Yes,
public money, you have to,
Yes.
it has to be repaid. There's no way out.
Yes, yes, we are going to repay, but Lordship, the last proposal we have submitted in the, on 11/8/2025, that is page 54, Lordship, with the upfront amount of rupees 2,30,000.
Yes.
But this proposal was rejected day after yesterday we got the mail.
Yes, we have rejected because the proposal which he has given is found to be on a more lower side, Lordship. And since 2017, Your Honor, just by this way or that way, he is taking time. And
2017.
2017, Lordship, there is no serious intention on the part of the petitioner to
How
make
much is
payment.
the outstanding now?
Now, Lordship, the certificate amount was for 52 lakhs in the year 2017. So now it have gone up. Most probably it will be above, 70 lakhs, Your Honor.
Now, Lordship, in the year 2023, the bank and the borrower entered into a compromise proposal of rupees 36 lakh 50,000. That is page 18. Lordship, and we have paid the upfront amount of rupees 3,65,000. This amount was not returned to us. So when bank has entered in the year 2023 with
How
us,
much amount are you willing to pay now? Upfront?
upfront, we have paid rupees 2 lakh.
No, 2,50,000. How much are you going to pay? Make an offer.
5 lakhs. Now we are ready to pay. At this stage.
What do you do? What is your business?
Business is a contractual work. But due to his cancer, the first stage of cancer, his business was not fully recovered.
Okay, you obtain instructions from your client. We'll have this on Monday. How much amount you are going to? As an exceptional case, we may grant some time to you, but you have to make an upfront which is reasonable, considering that the amount might have crossed 70 lakhs. We will also take into consideration that the OTS was for 36 lakhs 50,000. We'll take into consideration.
Yes, Lordship.
And bank also will consider definitely.
Lordship, only one submission. Lordship, since it is a statutory remedy of appeal, the reason he is not availing the statutory remedy is that he have to, pre-deposit 50%.
Yes, yes.
And when the first time, the compromise settlement was entered into, that was for rupees 36 lakhs 50,000.
Correct.
Only he paid the token amount of 10,000 in cash. Rest amount he failed, Your Honor.
No, 3,60,000 has paid.
3,57,000.
Yes,
3,67,000.
10%.
Yes, Your Honor.
10%.
But remaining amount, he could
Then
not.
he
Within a
he
period
was
of
struck
6
with
months.
some ailment.
But
That is what has been
payment
projected.
has to be made because he cannot, Your
Okay.
Honor, or
Uh,
bypass the
yes.
statutory remedy, Your Honor.
Pursuant to the order dated 3/9/2025, 3 S Das Granite Council, for the petitioner has served notice upon the respondent bank, full stop. The respondent bank has entered appearance through Sri Das,
G. Das Law.
G. Das, Learned Counsel, full stop. He has contended that the outstanding presently would be approximately 70 lakhs, and the petitioner had failed in his commitment even after the OTS, full stop. Para, on a specific query as to how much amount the petitioner would be would deposit to establish his bona fide, comma, Sri S. Das, Learned Counsel for the petitioner, has prayed for some time to obtain the instructions. Para, list for motion on Monday. You come up with a amount which is acceptable to the court. Yes, next. Mr. Vijay Ghosh, yes, Mr. Mazumdar?
May I have your lordship? In this case, lordship, NIT was issued lordship on 5/9/2024 lordship.
NIT
Lordship.
for
lordship 156 packages lordship. 159 numbers of packages roads lordship for construction of roads lordship. And petitioner participated for only one package that is in serial number 96 lordship. Annexure 33 lord. Your page 33 lord. Page 33.
Yes.
Yes. Thereafter, lordship, the petitioner lordship was found successful lordship, and letter of acceptance lordship was issued to the petitioner lordship. This is lordship page 65 lordship. Page 65.
This will go for bench 4, isn't it?
Yes.
It will go before bench 4. Cancellation of contract ultimately.
Yes.
Yes, Lord.
We don't mind taking up this matter, but it's a bench 4 matter. This before the appropriate bench.
Lordship, the another matter cancelling the issuing the fresh tender is pending on 8/9 lordship.
Lordship, initially he got the contract agreement was also signed, but subsequently it was cancelled. Lordship. That cancellation order was not communicated to him. That is why in the first round court directed communication of the order.
This has been communicated.
Subsequently it was communicated.
Okay.
Fresh tender was issued, Lordship. That tender, fresh tender is also under silence, Lordship.
In this case?
Yes,
No,
Lord.
Separately?
No, lordship.
Same tender.
This repetition is pending lordship 4799.
Okay.
It is reached on
Please before
8/9.
the appropriate bench, put stop. It is submitted that that an analogous WPC
4799.
4711
99.
99 of 2025 is slated to be listed on
8/9.
8/9. List along with the said writ.
Yes.
List this case along with the said writ.
Obliged.
Sri P. Nayak, Learned Standing Counsel, PWD is present. Because that's true.
I'm telling the order of demand service tax matter on the ground that there is a violation of section 73(4)(b). The issue is pending before the Honorable Apex Court. The Delhi High Court has favored the issue in favor of the SSC. Lordship has passed certain orders, my lord. In a similar matter.
The lordship can see the order in original was passed on 26/24, and they have approached this honorable court after lapse of 1 year, 3 months. And also, lordship, this order is an appealable order under the finance act.
No, but in section 73(4) is a jurisdictional issue, my lord. And Delhi High Court decided in favor of the SSC, my lord. Now department has gone to Supreme Court, my lord. Supreme Court not stayed the order, my lord.
What do you say?
That notice was issued. There.
Similar order already passed, my lord. I have given the copy to my friends.
We issue notice in other matters. We'll issue notice here. Same, make the correction, same
Right.
order. Okay, so notice is to hoga, huh? And see. We have issued notice and no
Lordship.
course of action. Okay.
Lordship.
We have mentioned that the matter issue is presently before the Honorable Supreme Court.
Apex Court, lord. Much obliged.
Madam, take this and make the corrections.
May I please, your lordship? My lord, eviction in that, my lord, Guwahati, Dalupari Reserve, my lord has already.
Similar matters.
Similar matter.
Matter 9.
Annexed at page 151, my lord. That's subsequent date. Similar matters are fixed on 9th, my lord, and so in those cases, my lordship was pleased to pass interim orders, my lord. So, my lord,
Mr. Proprietary, same order on 9th?
Wait, this is the last order, lordship may kindly pay. Originally, my lord, there were 3 petitions, one came thereafter, then this is the one.
But here there is no interim order.
Interim order was, my lord, extended, my lord.
Hmm? No, in the order placed on record by Mr. Borpujari, there is no interim order.
No,
Where is which is the order you are
My lord,
relying upon?
I am relying at page 192, my lord.
192.
192, my lord. The last, considering the facts and balancing the equities.
What is this writ appeal about?
My lord, the same area, my lord, eviction matters.
no, rate appeal pertains
No,
to
no,
matter
my lord, rate appeal pertains to
Ghat.
that Uriam Ghat, my lord.
Golaghat district. my lord.
Golaghat district, my lord.
This is, my lord, Patakil Reserve Forest.
And we are relying at page 192, my lord.
Okay, we'll grant the same interim order.
Mal.
Since we are fixing a date, 11?
Yes, my lord. My lord, 9th, my lord, 9th.
9?
9th.
Okay. Page 191, huh? Page necessary changes, huh? Common grounds. Now, we put the order. Heard Sri A.R. Bhuya, learned counsel for the petitioners who is apprehending eviction from the land under this position. Full stop. It is projected that the land is revenue land
Mal.
and there are documents to support such assertion. Full stop. On the other hand, Sri R. Borpujari, learned counsel for the
My lord, here, my lord, except 2, my lord, I will be.
Standing Council Revenue Department has submitted that the area in question was declared as forest land
First.
by a notification in the year 1966.
Yes, my lord.
Full stop. He has also informed that due to certain error on the part of certain authorities, portion of the land were allotted by the Revenue Department, which was without any jurisdiction. Full stop. Para, be that as it may, let notice be issued, returnable by notice be issued. Full stop. Three will accept notice.
My lord, I will be accepting notice, my lord. Except 2, my lord, for all the respondents, because here learned AG will be hearing, my lord.
Yes. Our book perjury for 1, 2 chor karke, for all the respondents except respondent number 2, which is represented by Sri R.K.D. Chaudhary, learned Deputy SGI. Also extra copies. Para. It is content, Bhuya, the learned counsel has submitted that in similar cases, interim order has been passed for maintenance of status quo. And those cases are fixed on
On 9th.
9th of September 2025, para. List this case along with those writ petitions, the lead case being WPC
4319 of 2025.
4319 of 2025. Full stop. The interim order passed in those cases of maintaining status quo shall also be operative in the present case, which however will be reconsidered on the next date.
And my lord, only one submission, my lord, we have filed a consolidated affidavit in that 4319, which will be relying for this.
Sri Borpujari has also informed that a consolidated affidavit in opposition has been filed in WPC 4619 of 2025. For sublet, a copy of the same be served upon Sri Bhuya, the learned counsel for the petitioner, to which he would have the liberty to respond by way of rejoinder affidavit.
Highly obliged, deeply obliged.
And so obliged.
My senior was in court lordship, we had to go to some another court lordship.
You are paid for vacation.
May I pray for vacation also, they have filed a state.
Vacation of the stay.
Lordship, may I pray for Monday, your lordship?
Who's for the petitioner?
I'm for the petition.
No, who's for the applicant? You are playing
Yes,
stay
it was
vacation.
on behalf of state.
You are on behalf of the GMDA?
Yes, sir.
What is the kind of stay?
Not to demolish the unauthorized construction.
Okay, there is an order of not to demolish. What is your case? It is unauthorized.
It's completely unauthorized, Lord.
What
Even
kind
he is
of-
not, he is
What
not
kind
even-
of structure?
It's a RCC ground plus one structure. Lord.
Okay. Okay, on Monday then,
Monday, Lord.
Monday. A prayer for accommodation has been made on behalf of Sri K. N. Chaudhary, learned senior counsel for the writ petitioner opposite party. Full stop. Sri Nayak, the learned counsel for the standing counsel GMDA, has submitted that the materials may not justify continuation of the interim order. Para. List for consideration on 9th. 9th, Monday.
Monday is 8th, your lordship.
8th. Interim order passed earlier to continue to the next day of work.
Wait, your lordship, may kindly go through the order dated 12/8/2025 passed by this court.
17 matter, what is the 17 matter doing?
My lord?
17 matter, what is it doing now? After in 2025? Was referred to facilitate. You were not made a party in the 34 proceedings.
No, whatever was here actually to be done, and she's also helpless today, as I came to know.
Also, I'm newly engaged also. Yes, expert.
Whatever matter. This Ghansam Chetri, he has 6 bigha of land in his mother's name. Mother died. Then he filed an application.
Mr. Sharma, you need not go to the facts.
Yes.
Ultimately, the award was the subject matter of an arbitration proceeding under 34.
Yes.
Your contention was that you were not made a party in the 34 proceedings.
Yes.
So therefore, you could not defend the case.
Yes.
That is your case.
Because Lordship, what happened? His name was not corrected. His name was not included in the new DAC number. So he has filed a petition before the Revenue Board of Revenue in 2011.
Now is it recorded?
Whatever
Now
matter-
is it recorded?
Yes, recorded.
It was correct,
2011, it was recorded.
corrected.
And when the proceeding was going on, it was in the name of
Since 2009.
predecessor was not there, expired
No,
already.
No.
U34
No.
can be redone. What is the problem? Give him
Later,
a hearing.
Lordship, his name was included in the new separate arbitral award was passed in his name.
Separately.
Yes, separately, because
So is
earlier
it-
5 persons,
Is
they
it
have
for the same plot of land?
same DAG number, Lordship.
Is the
That-
plot
that's-
same?
Yes, his land 1 bighas of
Then
1
we can observe that the award which has been passed, not the award, the 34 proceeding which has been done by hearing him, that will also cover this case. It is only the quantum,
Yes.
This quantum.
the
Because
quantum which has
earlier-
been ascertained in
Yes.
the proceeding where you have, you were present,
Yes.
that will apply to the other case.
Lordship,
Madam,
yes, what happened earlier actually, his name was not corrected. That's why he was not made a party in the Miss case, Lordship. The arbitration petition filed by before the district.
now what
judge.
we are thinking that instead of remanding the matter back,
No,
which will
he
again
actually-
again it will consume much time.
Yes,
You have said that in another similar proceeding, he was given a hearing
yes,
and that has culminated in an order pertaining to the same DAG.
same DAG, Lordship.
So the principles which have been laid down, or maybe the rate, that will be applicable in this case.
Rate, Lordship, same rate has been given to the other persons, they have accepted. Per rupees 5 lakhs per bigha.
And in the proceeding where Mr. Sharma was,
He's claiming 15 lakhs per bigha.
no, in the
As per
proceeding,
the earlier proceeding.
no, in the proceeding where he has been given a hearing, how much is the rate?
Earlier it was 1 lakh.
No, earlier my arbitrator fixed 5 lakhs. Then NSA went to the district judge.
No, 15 lakhs earlier. After that, they.
50,000,
15 lakhs, yes.
15 lakhs,
After that,
5 lakhs.
No, Madam Bora, a simple question. See, he is aggrieved by 134 proceeding where he was not given a hearing.
Yes.
The present case.
34, yes.
Now you have said that so far as another part of the land in question, in the same DAG,
Same
he has
DAG.
been heard. That has resulted in another another award, another order. What is the rate?
No,
Is there
5
any,
lakhs.
and this case,
In this case, Lordship, actually what happened earlier, it was, he has been, his written as 2,50,000 is not. Earlier it was 1,10,000. After that, they have filed a petition before the commission arbitrator. The arbitrator has passed an order by modifying this amount, compensation up to 15 lakhs per bigha. Later on, the NHI has filed a arbitration case under section 34 before the district judge. So district judge has modified the amount to 5 lakhs.
5 lakhs.
5 lakhs. After that, his name was included in the new DAG number, Lordship, this. So we have already, what happened? So we have issued the SEC also in his name. of
4,70,000 they have paid.
How much?
4,70,000. But
Per
the,
bigha, we have to give him.
but the
5 lakhs.
arbitral award of 15 lakhs, that was not challenged. So far I am concerned.
So
I
that-
went to, in spite of the fact that my name was not corrected, because it is my mother's land, I had filed an application before
Agree.
Sargam sir for Namdari. Nothing was done. Then I filed the application before the DC. DC didn't like that only. Then ultimately I had to approach the Board of Revenue to get my name corrected in the record rights. But against me, against that 15 lakhs matter, there is no 34 proceeding. And 35% would not lie, matter. If you also kindly just go through the Arbitration Act, 1996. There's total misconception proceeding, matter.
Same area, same DAG number, Lordship, other persons have been paid 5
Why
lakhs.
34 is not applicable?
No. I will. They will also only see 34.
Result will have to come.
Because his name was left out, Lordship.
Just a minute. Why 34 is not applicable?
What are the grounds to be taken in 34? Those grounds are not here. And they could have gone on the 36, but not 34.
No, 34, they have not challenged, they have to challenge 36.
36, yes.
Okay.
NHS should have gone
Oh.
under 36, not 34.
36 is for enforcement.
Enforcement, Malum, and
Why
also
36?
excelling the
Oh, dear, to now-
36 Lordship only.
36 for enforcement
Yes.
of awards.
It is nowhere been challenged also. And ultimately 34 will come out, 36 also.
Now, where is, this is the National Highways Act, 1956. Which act?
Yeah.
Sir, National Highways
96.
Act.
National Highway. What do you know? Eight. Arbitration against the
If you come to the section 3G, 6
3G6.
of the National Highways Act 1956.
Yes.
3G6.
Yes. It will apply.
Subject to the provisions of this act, the provisions of the Arbitration and Conciliation Act 1996
Shall apply.
shall apply to every arbitration.
Yes. Arbitration case to three parties.
So there is a specific applicability of this, of this section of this act. Because if you read subsection 5 of 3G, amount determined by the competent authority, that means the CALA, CALA.
Yes.
Under subsection 1 and 2 is not acceptable to either of the parties, amount shall, on an application by the either of the parties, be determined by the arbitrator to be appointed by the central government and subject to the provisions of the provisions of arbitration and conciliation will apply, shall apply to every arbitration. So that determination has been done by the competent authority.
Yes.
And you had approached the arbitrator.
Yes.
Now the award of the arbitrator can be challenged under section 34.
34. The 34, what are the grounds? When you can challenge, one can challenge. That's why I come to 34. An arbitrary award may be set aside by the court only if the party making the application establishes that on the basis of the record of the tribunal that the party was under some incapacity, the arbitration agreement is not valid, there is not there.
You have to file an appeal if at all. If you say that 34 was not maintainable, you institute an appeal under 37 before this court will examine. How do you institute a writ petition?
Actually, my lord, what happened here, there is a mistake, of course, on the part of the lawyers also. Actually, it should be gone for execution. Because it is an award, a decree under the CBC. Decree, since it is a decree under CBC, so order 21 will come into play.
Yes.
So it should be for execution. So now only option left, if at all, if this court says so, then I have to go for execution.
No, but you said that you are aggrieved by the award of the arbitrator of the 34 court.
No,
The court
in the
exercising
34
powers
court,
under
I will not made party.
No, you are aggrieved by the order passed.
No.
You are not aggrieved.
No, I am not that. What I came to this court for is that since the award has been in my favor by the arbitral tribunal,
Yes.
so there should be enforced. So that's why it was filed. So, but we should have gone for execution since that award was not on a challenge and there was no interference by the district judge.
Your contention is that, my lord, rupees 15 lakhs has been reduced to 5 lakhs. In the while passing that order, they were not the party, my lord, but the same place, my lord. Had they been party out there,
Mr. Sharma, perhaps you are not properly instructed. The district judge has passed an order on 19/4/2012.
Yes.
In miscase which was filed under section 34 of the Arbitration Act.
Yes.
There was a modification of the order.
Yes.
Now you cannot go for execution of the original award that has been
Since I was
modified.
party there, my award was not challenged.
So if you are not a party, you can prefer an appeal under 37 before this court.
Yes,
How
but
can you entertain a
that's what
court?
I am saying. Then I
File an application,
I
file
should
an
go-
appeal, but appeal is barred by now.
No, not appeal, my lord. I will have to go to execution.
Execution of an award which has already been modified.
Modified.
What do you execute?
Modified not against me, against others.
His name was not there at that time.
I will not know how it is going to help you.
It's only one I did, yeah.
See,
Because I was not party, so that will not be applicable to me.
The modified order will
So
not
if
be.
you think in that manner, you can go ahead with the execution. We have nothing to do.
Yes,
But,
fine.
but to be very fair, there is an order of the district judge who exercised powers under 34, modified the award.
Yes.
The moment you go for enforcement under 36, this will be a stumbling block for you. Executive court will say that this has been modified. How do we enforce an
Well,
award which has not been modified?
Suppose, Malad, there is a decree. But in the decree, if the 34 is to be treated as a decree, I am not party. Suppose Munsub holds in favor of me, and this is modified so far as other persons are concerned. My decree given to Munsub is not challenged. So there is sacrosanct. I would
Then you can, a few things that we have nothing to comment. You can withdraw this and you go for 36 enforcement, and it's up to you.
just a minute.
But we still think that you are not on the right direction.
No, I'm in the right direction because my award is not challenged. So I am on the right
It's a
direction.
composite award. It's a composite award.
Maybe
It
the
was put to challenge.
Mhm.
34 court has modified the award. Then can you go for execution of the original award?
See, otherwise they would have made me party. They would have made me party.
You can
Because
challenge the
my name was
34
recorded by the
order
order of
under
the.
37. There is no bar.
Let me.
Okay, we'll come back at 2 o'clock. If you want to
No,
withdraw and go for
I'm leaving out, Malo. Let it come some other day. I'll just go to further develop it.
Okay. But 17th matter, we want to dispose this of.
Yes.
No point holding this back.
Next,
Come back at 2 o'clock. Are you around at 2
No.
o'clock?
I want to go out, Malo. Your lordship knows.
We do not know. Where do you want to go?
To my constituency.
Oh, then we cannot stop you.
Yes. So let me next Thursday, my lord.
Next Thursday, okay.
Yes.
On a request made by Sri Sharma, RP Sharma, Senior Counsel for the petition, matter is returned to be listed on Thursday next. Ms. R. Bora, Learned Pending Counsel, National Highways, and Sri Endas Learned State Council are present. Mr. Chaudhary, which matter? One matter we had fixed.
2 o'clock. That unlisted motion is pending.
No, one IA for stay vacating. We'll have
Yes.
some
That's
Thursday.
fixed on Monday.
Monday is. Which matter is there now?
Vidyut metal is there is one matter.
Oh, 17B.
Yes.
17B will trouble us to this. Okay.
My lord, it's a covert matter, my lord.
By lordship order, my lord.
Covert
H.
matter, my lord.
Borwa on behalf of B. Gogoi.
B. Gogo's name may be recorded, my lord.
B. Gogoi. Cover code. Yes, please give the.
My lord, in this matter, we have received our instructions, my lord, Paravas comments, my lord. We'd like to bring it on record, my lord.
Then we issue notice.
My lord, I have intent there because my GST is suspended. Lordship may fix next Wednesday in the meantime. If they want to bring on record, they may bring on record, my lord.
Will it be possible to file the affidavit by next Wednesday?
Yes, my lord. We'll file it. my
Okay, then we have it on Wednesday.
My lord.
Yes, my lord.
Third, Sri R. S. Misra, Learned Counsel for the petitioner. Para. Sri H. Barua, Learned Counsel, appearing on instruction of Sri B. Gogoi, Standing Counsel, Finance within bracket Taxation Department, has however submitted that instructions have been received, and he would put the same on record by way of an affidavit. Full stop. Para. As the urgency has been expressed by the petitioner, by the Learned Counsel for the petitioner, list this case for motion on Wednesday,
My lord.
10th.
Much obliged.
Obliged, my lord.
Who to huh? Four to it was it?
Three is covered, 4 is there for time, my lord. 3 is lordship.
Four is Wednesday going.
4 is fixed on, was fixed
4
on
is fixed
Wednesday.
on
my lord.
Wednesday.
Wednesday, my lord.
Four order.
Three
Three
is
to cover.
3 is covered, my lord.
So I do is dispose of.
Simple prayer, my lord. In item 8, under standing
What
counsel
is
of
a simple prayer and what is a complicated prayer?
lordship. Lordship, item 8, my name is not reflected. In fact, no copy was served to me, lordship.
Yeah.
I have informed just now by one of my senior.
We have passed orders in eight.
Notice says, it's lordship, my name may be reflected only. That must pray.
That has been already signed and uploaded.
Obliged.
Sabas minute to us, Rajin. Bajrang Kumar Chaudhary.
SCWMD may be reflected. Next that I will try.
SC?
WMD,
What is WMD?
Welfare of Minorities and Development Matter.
Okay. What was this case? Yes.
Item number 8.
Yes. Mutawali, yes, Wakf, okay.
I'm so deeply obliged, my lord.
WMD,
Lordship,
Welfare of,
Minorities and Development.
it was the Maris Maranas, I took good, huh? But I think we directed for taking steps by registered post to DD, I did not know. We'll check.
Lordship,
I think R. Sharma was there, the council, R. Sharma. Please contact him.
obliged, lord.
Twenty.
Lordship, can you produce the last order? In terms of the last order, my learned friend has served a copy of the writ petition only just now only. May I just pray for a very short date?
Why
Let me
was
get
this was in way back in 11/8, today is what?
Yes.
Almost a month.
Yes.
Actually, my lord, we tried to serve copy to the junior of madam, but the junior did not.
No, my goodness, you're always here. I am always here, Your Lordship. That's a slightly vague prayer which is being made, but
Okay,
very short
Ms.
date.
R.S. Chaudhary, Learned Standing Council, Assam State Legal Services Authority has informed that the copy of the writ petition has been served upon her only today. First up, she pays for and is granted 2 weeks' time
Lordship.
to obtain the instructions. List of the tools.
Deeply obliged, Lordship.
Vidyut. Yes, Vidyut.
Lordship, April, Lordship, after some time, Lordship, this machinery is coming up.
Okay, after a while.
Okay.
But make it faster.
Lordship, he is on his
There
way,
is some meeting.
Lordship.
Industry disputes একটা হলো আছে।
26.
Late legal lordship. Lordship, in this case, pleadings are completed, lordship, let the matter be fixed on another date, lordship. Pleadings are completed, lordship, let the matter be fixed on
What
another
is
date.
the matter about?
Lordship, the petitioner has challenged the order of the respondent authority wherein one-man committee has been appointed, lordship. At present, one-man committee is running the state authority, lordship.
Why no election?
There was a stay from the Honorable Court, my lord. The Honorable Court has directed the one-man committee should continue to run.
You are challenging the one-man committee.
Lordship, no, I am challenging the order dated 10/10/2020, page 83, lordship.
Yes.
Wherein our committee was dissolved, lordship, and one-man committee was appointed, lordship. Thereafter, the petitioner approved this honorable court, lordship.
But the stay order is not helping you.
My lord.
Not helping you, lordship, any day, lordship. Today I am not.
Then you go for a fresh election.
My lord.
What was your term?
Lordship,
Your 5 years term expires when?
our term is from 27/9/2022, lordship, till 27, lordship, 2027.
27. Why was this one-man committee appointed?
My lord, they had failed to hold the meeting.
Of 41-6.
My lord. So the committee was dissolved and ordered for fresh elections.
Okay.
That is the.
Then if you, it's the, as per the statute, one-man committee, now one-man committee will hold fresh elections. You participate in that?
Lordship, next week, lordship.
Yes, my lord.
Huh?
Yes, my lord. We are.
Because this the one-man committee is only an ad hoc arrangement.
Lordship.
Where is the? (41-6), isn't it,
Only
Mr.
for 90 days, ma'am.
Goswami?
Yes, my lord.
And why would the registrar shall convene a general meeting by appointing an officer of the Cooperative Department for constitution of the board within
90 days.
90 days from the date of such appointment. And the officers who are appointed shall perform also and so. See, this was a very stopgap kind of an arrangement, 90 days. That has expired long time back.
Lordship. Lordship, our whole contention was that, Lordship, we have hold the meeting on the stipulated date, Lordship. That was our main contention, Lordship.
What do you say on that?
My lord, they had not, the meeting was adjourned, and after that, they had reconstituted the meeting and held it on their own without any notice being published. So all members were not present, my lord. So because there was not a duly sanctioned.
Mr. Butler, this stay order is benefiting none.
Lordship.
We can ask them to hold an election in accordance with law within a specified time. You participate, you are the directors.
Lordship.
You participate, you get yourself elected.
My lord, as per
Because from 23 till 25, 2 years have already gone.
Lordship.
My lord, as per section 40, they will be debarred, my lord, if they fail to hold the meeting. That is clear.
40.
40 clause 4, my lord. 44 subclause A. 40 subclause
This
4
committee-
subclause A.
This committee may be allowed to hold the meeting, Lordship.
Subclause
4, my lord.
4 then
A. Not conducting or wrongly conducting the annual general meeting under section.
or that will be that will question their eligibility.
My lord.
Oh, then question would come.
That would-
But these will be factual disputes if you say that you had
Lordship.
held the meeting within the
Lordship.
stipulated
In
time
fact-
and they are disputing.
Lordship.
How do you prove?
We have filed our affidavit, my lord.
Now, how do you prove, Mr. Butler?
In this regard, we have submitted one representation on the day itself, Lordship. When the meeting was conducted, Lordship.
We can have a via media, we can say that the disqualification will not apply so far as the petitioner is concerned. Since it's disputed, let them also contest. And you are also interested parties.
My lord, we are affected party, my lord, because due to my lord interim order, my lord, about 3 years, my lord, society could not run, my lord. It is
Okay.
an agricultural society.
Okay.
And though the one.
Who are you? You want to be
My lord.
directors?
No, my lord, we are not director, we are the general members, my lord. Shareholders, my lord. We are the general members. Society is affecting since long. It is the agricultural society, about 400 acres of land to agriculture. But one-man committee did not take, my lord.
Mr. Butler,
Lordship.
we will make an observation that the disqualification under 40 will not apply.
Lordship.
Let within a time bound frame, the election be conducted, meeting be held.
Lordship.
Okay. Hussain for whom? 8, 9, 10,
My lord,
11,
yes.
12.
12, my lord.
Okay. Please have a seat. Heard 3 P. Borderline, Learned Counsel for the petitioner. Also heard R.B. Goswami
I'm appearing on behalf of Mr. MD Bora.
of Mr. M.D. Bora.
My lord.
Learned Counsel appearing on instruction of Ms. M.D. Bora, Standing Counsel, Cooperation Department, comma, Sri B.J. Tarukdar, Learned Additional Senior B.J. Tarukdar report लिखो, हाँ? That's what R.B. Goswami. Also heard 3 M. Hussain, H.O., huh? Yes, yes, sir. Learned Counsel for Respondable 8, 9, 10, 11, and 12. Full stop. Para. Considering the subject matter involved in this petition, which is pending since the year 2023, and also as agreed to by the learned counsel for the parties, comma, this petition is taken up for disposal at the admission stage. Full stop. The petitioner was selected as the president of the, what is the name of the committee?
Vishwanath Dogaon Krishi Palm Samabay Samiti Limited.
Of the Vishwanath Dogaon Krisipam Samabay Samiti Limited in its 40th annual general meeting held on 27/9/2022. The said cooperative society was registered in the year 1979. Full stop. The petitioner has contended that the 41st annual general meeting of the society was scheduled to be held on 23/9/2023. Full stop. However, certain members who had defaulted, as well as their family members, had created some unruly situation for which the meeting had to be postponed, which was accordingly held on 30/9/2023.
Lordship.
The petitioner has asserted that the quorum was fulfilled and the meeting was held in accordance with law, the records of which was also forwarded to the respondent authorities for approval. However, by the impugned order dated 10/10/2023, the
Page 83.
Board of Directors was dissolved on the ground that the annual general meeting for the year 2022-23 was not held within the stipulated time. Sri Bodole, the learned counsel for the petitioner, has submitted that the meeting was scheduled to be held within the stipulated time on 23/9/2023, which, however, had to be postponed to 30/9/2023, on which date the meeting was duly held and the proceedings was forwarded to the respondent number 6 for approval. He has submitted that there was no occasion for invoking the powers under section 41 within bracket 6 of the Assam Cooperative Societies Act 2007. Full stop. He has also emphasized that the appointment of an one-man committee is only a stopgap arrangement, and continuation of such a committee for a long time is against the scheme of the Act. Full stop. Sri Goswami, the learned counsel for the department, has submitted that the impugned order dated 10/10/2023 was issued by strictly following the mandate of law, more particularly section 41 within bracket 6. Full stop. It is submitted that the AGM could not be held within the stipulated period which had required passing of the order dated 10/10/2023. He has also submitted that it is because of the interim order passed by this court that no fresh AGM has been held. Full stop. The learned counsel has also drawn the attention of this court to section 40 of the Act on the aspect of eligibility, and has submitted that the earlier directors would be rendered ineligible under the aforesaid provision of law. Sri, where is Mr. Hussain? This side. Jumped. Lalit changed. Parties changed. During the proceeding, we have not seen this before. How did you come to this side? You are here. No space.
No, it's
Wherever you get space, you will come. That is even more dangerous. Sri M. Hussain, learned counsel, has submitted that his clients are the shareholders of the society, which is an agricultural society, and because of the present impasse, IMPPESSE, the public interest is being adversely affected. Full stop, para. After considering the facts and circumstances, comma, this court is of the view that the provisions of rule of section 41(6) of the Act is that the provisions for appointment of a one-man committee under section 41(6) is only a stopgap arrangement so as to facilitate holding of a meeting for constitution of the board within a stipulated time. Full stop. It, however, appears that while issuing notice in this case on 17/11/2023, an interim order was passed, and on the strength of the said interim order, the one-man committee is functioning. Full stop. Para. The scheme of the Act of 2007 is that of a self-governance, and appointment of a one-man committee, as mentioned above, is only a stopgap arrangement on happening of a particular eventuality. Full stop. Para. In the instant case, it is the petitioners have projected that there was no default as such in holding the AGM within time, and the postponement from 23/9/2023 to 30/9/2023 had to be done because of circumstances beyond the control. Full stop. It is also asserted that on 30/9/2023, the meeting was held in accordance with law and by fulfilling the quorum required. Full stop. The said aspect, however, is disputed by the learned counsel on behalf of the department. Para. Without going into the said aspect of the matter and taking into account that sufficient time has elapsed since the institution of the case, and the committee itself was constituted in September 2022, this court is of the opinion that the interest of justice would be served and the balance and the equities can be balanced if a direction is given to hold a fresh AGM in accordance with law. Full stop. Full stop. This court, at this stage, this court has also considered the provisions of section 40 on the aspect of eligibility. Full stop. Para. After taking into consideration the facts and circumstances, it is provided that the eligibility put by section 40 within bracket 4 shall not come into the way for the erstwhile directors to contest in the election if so interested. Full stop. The elections, the AGM and the elections be held within a period of
Within periods, Lord.
2 months.
3 months, my lord. It will
3
take
months
some time to
is-
issuance of notice and etc. My lord, this may not be precedent for all other
Yes,
cases
yes,
because
yes.
that lordship may kindly
Yes.
observe because 44 is.
Yes,
clear.
within a period of 3 months from
Lordship.
today. 3 months from today, full stop. The observation of this court on the applicability
Yes,
of section 40
4.
within bracket 4 of the Act shall not be a precedent and has been passed only in the facts and circumstances of the present case.
Deeply obliged. Lordship may kindly record my name.
Already recorded.
Obliged, your lordship.
Deeply obliged.
May it please your lordship. My lord, the matter relates to election of president of a Gaon Panchayat. Now, what had happened in this case, my lord? 3/7/25, the first meeting of the Gram Panchayat was held, my lord. After the oath, the election of the president and vice president was taken up. For the president, the petitioner and respondent number 6 both secured 5 votes. Therefore, the authorized officer, my lord, resorted.
Toss.
Yes, toss. Now, if your lordship would kindly come to page 32.
Yes.
Yes. Beloved, this is the English translated copy. Today on 3/7/25, Thursday, election of president was conducted through secret ballot for both the candidates, namely Ayesha Begum and Surjana Begum Tapaddar. Beloved, Ayesha Begum is the petitioner, secured 5 votes each equally.
Yes.
As the government guidelines, we have, as per government
Suzana is
guidelines,
R4, R6.
yes. Surjana Begum Tapaddar is
R6,
R6,
okay.
beloved. Yes. Secured 5 votes each equally. As per the government guidelines, we have no objection in holding the election of president by lottery, that is toss, and we will agree with one who win as such, and we'll have no objection to that. So, my lord, both the candidates have chosen to put their signature.
The coin was not the Sholay coin.
No, that is not the issue. Oh, Sole coin, both sides.
That is not your case.
Ayesha Begum, she preferred head, my lord, and Surjana Begum Tapaddar, she preferred tail.
Yes.
And it so happened that as per the toss, it was head. So therefore, the petitioner won, and she was declared elected.
Oh, you were elected?
Yes. Now, my lord, the vernacular is in page 33, my lord.
Yes.
I think my learned friend will have slightly difficulty in Bengali reading.
No, we have read it.
I put yes.
Is there any discrepancy?
এবং কি সভানেত্রী নির্বাচনে আমাদের কোনো আপত্তি নাই এবং যিনি জয়ী হবেন উহাতে আমাদের আপত্তি থাকবে না. So whosoever wins will have no, and therefore they accepted the result. Now, my lord, a question.
But have you seen the handwritten as per TOSS, TOSSH? Emphasis is there.
Now, my lord.
Barak Valley.
Barak Valley.
H will be there.
Yes. Now what happens? After this happened, my lord, one writ petition was filed by the my lord respondent number
Suzana.
6.
R6 file writ petition.
Yes. And that order is at page 34, my lord. And the operative portion is at page number 37.
Okay.
Para 9, a perusal of provision of section 11 would go to reveal that any dispute relating to validity of election of president and vice president of Gram Panchayat under this act shall be decided by jurisdictional district commissioner.
Okay, it was sent to the district
It
commissioner.
was sent to the district commissioner. Now, before I take your lordships to the order passed by the district commissioner, my lord, please come to this page, my lord, that disputed ballot, my lord. Page 2. Page number 30, my lord.
30.
Yes. 31, my lord. In fact, that is the copy. Now, my lord, the petitioners, this was the petitioner's vote, my lord, and it was slightly, on the other side also. Now, there is a, my lord, manual issued by the election department Copy to dear. How this is to be treated, my lord? Is to kiman asin? Yeah, go. 24, 82.
If it is touched, same cover one. Last part is comments. Any comments are said?
My lord will kindly come to page 24.
Yes.
Valid ballot paper sample. Now please come to serial number 2, Milan Kakoti. Similar is the case, Miller, as in the present case. Now
Serial
kindly see the remark,
Page
Miller.
24
Page 24, Miller.
of the writ petition.
No, Miller, of this compilation.
Okay. Okay, this flat
Yes.
part, yes,
Kindly see, Miller, valid ballot paper sample.
yes,
Now serial number 2, Milan Kakoti.
yes.
Now this is how it was voted. Then reason, vote in favor of Milan Kakoti. So
Yes.
this is a valid vote.
Okay.
Now, my lord, now in the present case, one very important question arises. Of course, I'll also rely upon section 11(9) for that. Now, as per rule 45 of the rules, once there is a tie, it has to be resorted to toss. Now, that has been done. Now, my lord, in what the deputy commissioner did, my lord, he went to the extent of deciding the validity of this vote. This aspect was over. Supposing if you'd have won, if respondent number 6 would have won on the toss, would she have complained for this? And section 11(9) is very important. Now, before I come to 11(9), I'll go to the impugn order by which the appeal was disposed of in terms of the order passed by the coordinate bench. Page number 44, Miller. My lord, I'll draw your lordship's attention to the last two paragraphs at page 44. Whereas authorized officer Kaushik Datta decided to count the said ballot in favor of Srimati Ayesha Begum, as majority of the mark appeared within her space, thereby treating the intention of the voter as clear. Whereas after counting, both the candidates secured five votes each, and tie was resolved by toss of coin. Both parties had agreed to the toss beforehand, as corroborated by video evidence. Upon winning the toss, Srimati Ayesha Begum was declared president. So the deputy commissioner also admits the position that they had no dispute all throughout. Whereas the petitioner Srimati Surjana Begum Tapaddar objected that the disputed ballot was improperly accepted and should have been rejected under Rule 46(7)(b) and C of the Assam Panchayat Constitution Rule. Whereas Advocate Sri Dayan Hussain, Learned Counsel for the petitioner, argued the voter concerned had the minimum educational qualification prescribed for the contesting Panchayat election and hence was educated and not ignorant of the process. Voting procedure has been explained to all present. Therefore, the deliberate placement of mark overlapping both candidate space indicates the voter intended to invalidate the vote. Consequently, the ballot attracts Rule 46(7)(b) as mark against more than one name and Rule 46(7)(c) doubtful mark and ought to have been rejected. So this was the contention of respondent number 6. And our contention was the intention of the voter must be preserved wherever reasonably ascertainable. The bulk of the mark lay within the space of Srimati Ayesha Begum with only minor slippage. That this was likely human error rather than a deliberate invalidation. Ballot was therefore rightly counted as valid. Now, Miller, kindly come to whereas. Now, rules are quoted. Now, please come to the last para. Now, therefore, I, Pradeep Kumar Dwivedi, as Deputy Commissioner Sri Bhumi, in exercise of the power conferred under Section 11 of the Assam Panchayat Act 1994, hereby hold that the disputed ballot, though counted in favor of Ayesha Begum by authorized officer on principle of voter intention, creates sufficient doubt as to certainty of the voter choice owing to overlapping placement of the mark. In terms of Rule 46(7)(b) and 46(7)(c) of the Assam Panchayat Constitution Rule, such a ballot is to be rejected Accordingly, the rejection of the disputed ballot, the final tally stands as follows, 5 as against 4. My lord, I am the candidate. So my intention, my lord, can it be gathered like this? A subjective satisfaction. On the one hand, my lord, number 1, in terms of, now before that, may I make my submission? Possible, kindly have the act, my lord.
Yes.
Subsection 9 of section 11. Is it? Is your lordship holding that book?
Yes,
my lord?
yes.
Yes. Please come to subsection 9, my lord. No?
46.
Eh?
Section 46.
Huh?
46.
No, no, subsection 9 to 4. Rule 9. Right? Sorry, my lord, rules. I'm sorry.
Rule 46.
46 sub rule 9. Yes, yes. That is, my lord, rules of 1995.
Constitution rules.
Yes.
Constitution rules.
Constitution rules. Sub rule 9 of rule 46. Not 11, and I'm sorry, my lord.
46.
169.
Yes.
Declaration as to election of the president and vice president of Gaon Panchayat under sub rule 8 by officer authorized shall be final. My lord, this shall be final except qua 226 proceeding. Now, both parties agreed, everybody has put their signature. The dispute was regarding, my lord, toss of coin. And even if there was a right, my lord, that right has been waived by the necessary by conduct. Now, where was the scope for the deputy commissioner exercising power under section 11 to go beyond the mandate, my lord? So therefore, my humble submission is, my lord, this order needs to be examined, my lord. Now, there is no way, my lord, they could have gathered the intention to invalidate the vote when the candidate herself was the voter itself was a candidate. That analogy could have been, my lord, drawn in case of a voter other than the candidate.
Now, how do you know that this is the particular ballot paper is of the petitioner?
No, it was known, my lord,
No, no.
during the course of the.
It is a secret ballot.
No, subsequently it was shown, my lord.
No, shown.
But initially I was not
you
aware.
cannot identify a particular
Subsequent.
paper.
Subsequent.
It
No,
can
that
be-
is not an issue. I was just trying to make a my lord, ancillary argument. That is not my principal plan.
But
My submission is, my
Mr.
lord,
Chaudhary, two issues you'll have to answer.
yes.
First is that we would have accepted your argument without any problem. Toss of coin is permitted.
Yes.
But the first round of litigation, which was instituted by your
Yes, yes,
adversary,
yes.
if you read paragraph 4,
Yes.
the contention of the petition at come page 35, page
Yes,
35.
my lord.
Order of 21/7/2025.
Yes.
Contention of the petitioner, that means the present
Yes,
respondent,
para 4, yes.
is that while she had received 5 numbers of votes in the election, the respondent number 8, that means you, had secured only 4 numbers of votes.
Yes.
That was the consistent stand.
No, that was one. And para 4, this later part of para 4 is regarding the other one.
What is the other one?
The resolution was adopted by the House for having election of the president by of a toss. It is the contention of the petitioner herein that although she called tails and the coin on being tossed had come in favor of the call made by the petitioner, but authorized officer declared that the coin on being tossed had reflected head. Sir, her grievance was that she had called for tail and in fact it was tail, but the authorized officer wrongly called it head.
Okay. Then the second question.
Second question.
Second question is that.
Second question was not even answered.
No. Second question is that.
Yes.
Which I would like you to respond.
Yeah.
Is this court had remanded the matter.
Yes.
For adjudication.
Yes.
Now that part after the court's order, though you may be correct in contending.
Yes.
That under 46(9) finality has come.
Yeah.
So you can challenge it by writ proceeding. It's a different matter.
Yes.
But the leeway given by the court that cannot be
My humble submission is even if a leeway was given by the court, end of the day, my lord, can the deputy commissioner ignore 46(9) and the, my lord, records of the case where it was clearly indicated that they have no problem as regards the, my lord, position prior to the toss of the coin. Everybody has put their signature. So is it not a case of waiver? Even if she had a right, it's a, my lord, voluntarily giving up a right by putting her. She should have objected. Sorry, I'm not signing it. there's no question of toss because one vote is invalid. That has not been said. So therefore, it's a case of waiver, my lord. It's a voluntarily she has given up. So therefore, it was the scope for the appellate district commissioner under section.
Yes, Mr. Borbia.
My lord, the contention of the writ petitioner is not correct, my lord. Lordship kindly have a look. The modality given page 27.
Yes,
Lordship kindly see the page 27.
yes,
There, my lord, if the line is crossed
Yes.
like this, my lord, Lordship kindly, that is to be treated as a cancel breach. That is the invalid.
no, but see, on the second leg of argument, that you had acceded to the procedure of
No, my
having a
lord, we have
toss.
objection, minutes
No, no.
very much clear.
No, no, that objection you cannot have because it has been recorded that not only you have exceeded, you had said that you had called for some head. It was head, but
My
there
lord,
was some.
it is the overrating, my lord. Lordship kindly have a look, my lord.
No.
How the manipulation
Mr.
was
Borbia,
done.
that is not the,
Yes,
our question is slightly different.
my lord,
We are not on the outcome of the result of toss.
my lord.
We are on your acceding to the procedure of toss because you have also made an allegation
No.
that in the toss, it was you who had,
My lord,
won,
I'll
but
just-
there were also
I'll
some
just
manipulation.
clarify,
That
my lord.
means,
Before, my lord, entering to the voting center, my lord,
yes,
they take as a attendance, and that is to be treated as a, my lord, consent letter. That is not the case. My case is, my lord,
Mr. Borbia,
I
that is-
filed
that-
a writ
Mr.
petition.
Mr. Borbia, that is the only reason we are trying to get your response.
My lord,
We understand
my lord,
that you did not consent. Let us take it that you did not consent for a toss. But what is your second contention before the learned single judge in the first round of litigation?
my lord. It is there, my
You are alleging that in the toss also, there's some manipulation was there.
watch
That means-
also override.
that means you had acceded to the toss.
No, my lord, I have not
Then
accepted.
where is your second submission comes from?
Lordship.
Come
We
to-
have, we
come to
have
page
filed a writ
36.
petition in both ways. my lord.
Yes, both ways. You are challenging.
I challenged the writ petition
This was
both
not,
ways, and honorable,
unless you put it on, it's a part of the pleadings, that
My
in the
lord.
toss also there was manipulation.
yes.
You could have very well said I did not even consented to toss. You had two legs of arguments.
These also I have challenged, my lord. Minutes also reveals like that. If your lordship permit me, I'll just read out the minutes, my lord. Amra petition, the Agir petition. I'll just read out the small paragraph, my lord. Minus two mark karo.
So third line that says, page 36 again, let us read again, page 36, second line,
Minus,
order of the court,
minus two.
page 36.
Page 36, my
Yes,
lord,
second line,
from the top.
top. It is the contention of the petition, that means your contention,
Yes,
that
my-
although she had called tails, that means you participate in the process of toss.
participate. Participate. But we have objected.
Shouldn't have participated.
My lord, we left, my lord. That's why, my lord, maybe.
No, this is your statement.
My lord. That's
Record
why,
not
my
only
lord, lordship
statement
kindly,
recorded by the court.
lordship kindly permit me to read out the minute, my.
Yes, page.
English for na, minus. Are Bengali ta for. No, mat karo to ta my. Lordship
page?
kindly see page 24.
24.
My lord is the type copy.
Yes.
After election of president number so and so, the Panchayat below named members left the meeting respectively. Fatima, number one, Majuruddin, Bina, Surjana, and other.
Surjana is you. Surjana is you.
I am the one.
You are Surjana.
Yes, ma'am.
Respond number?
We left the meeting. Response number 6. Surjana Begum, Tapadar, ward number, this serial number 4.
Yes.
Thereafter, the in charge of the officer called the vice president so and so according to Janara Pal and of the so and so. We left my little meeting.
Yes.
There is objection. Both ways. Now
le-
she will see.
When did you leave the meeting? Did
My
you
lord,
leave the
they-
meeting before the toss or after the toss? You have to read the earlier
My lord,
paragraph.
the moment we came to know, my lord, there is a manipulation. That very moment we left.
Please read the earlier part of this resolution.
Lordship.
Earlier
Resolution
paragraph.
also prepared by them, my lord.
No, you're banking upon one part of the resolution. You have to read the entire, at least
My lord,
read
I'm
the
just-
earlier paragraph, page 23, last paragraph.
Uh,
Since
Since the names of two ward members were proposed for the post of president decided to elect the president through the direction. Finally, the election process was conducted through the secret ballot as per the Assam Panchayat. Srimati Surjana Begum Tafadar got 5 votes and where the Aisha Begum got 5 votes. That is not wrong, my lord. They got 4 votes. This is the.
that is, both the candidates got
both-
equal votes.
Both got the equal votes, therefore the in charge of the decided a decision was taken to elect the president through lottery toss. All the members agreed to it and out of 2 candidates, Srimati Surjana Tapadar preferred the coin tails. Since Surjana Aisha Begum preferred the coin of the head, thereafter the in charge officer conducted the lottery and in this coin over and above chosen, the Aisha Begum was selected in the lottery. Thereafter, the in charge of the officer declared Srimati Aisha Begum won so and so President Udampur Gancho as per lottery. And Lordship kindly see the particular. Page 28, man. Lordship kindly see the particular.
28,
28.
yes.
8 number line, Lordship kindly see from the top.
When they have fully tempered.
Yes,
Lordship has seen my line.
yes.
The overwriting,
When they
coin, head, tail,
have tempered.
they have tempered it. We have objected, my lord, and we left the meeting. Now, Lordship, kindly come to page 31. 31 comparing, my lord, page 27, my lord. The contention of the writ petition is not correct. If it is half of the line, now it is cross line. Page 27 and inner page, my lord, of modality. Extreme right hand, my lord. Ananda Sharma. Lordship has come across. Page 27, Ananda Sharma.
Page
27 of the modality.
27. Where are the pages? Okay.
Inner, my lord, bottom.
Ananda Sharma, yes, yes.
Lordship has seen and page 31, Lordship make a compare.
Line.
If the line cross, my lord, that is to be invalid. And page 24 is different, my lord. Half line is my learned senior counsel has referred, my lord. That is altogether different, half line. Now, my lord, line cross as like a page 31. That is the invalid. Accordingly, my lord,
Let us
deputy
see the
commissioner has
let us
passed.
see the impugned order again.
Lordship kindly see the impugned order at page.
Page 45, last parameter, the observation.
Lordship kindly, oh, it starts from 44, my lord. Operative part, my lord, 45 will whereas the petitioner Surjana Begum Tapadar objected, Lordship kindly see that I have objected. The disputed ballot was improperly accepted, should have there been rejected. Under rule 46, that is the I have shown just now. Modality, I have already, then and there I have objected. Minutes also there. And all these things are recorded in the video, my lord. All video record, nothing, my lord. After perusal of this thing, my lord, the deputy commissioner pass order, my lord. Then Lordship kindly see accepted.
Where is it? Where is it mentioned in the order that there was a video thing?
Yes.
Video.
I think page, no, very proceeding of this.
No, the deputy commissioner has, district commissioner has looked into the video.
Page 44, my lord, that was the bottom. Whereas after counting both candidates,
Video
as
evidence.
corroborated by video evidence.
Upon winning the Srimati Aisha declared president Whereas petitioner Srimati Surjana Begum Tapadar that objected and disputed the ballot. Who have objected, my lord? Is the part of the video, my lord? Video seeing, my lord, Deputy Commissioner is saying that we objected.
Yes, Mr. Kumar, you appearing.
And Lordship, one more thing, my lord, Lordship, Rule 9 they have relied upon. Section 11 says something different, my lord. Lordship, just 3 paragraph, my lord. Section 11, any dispute, may I read, my lord?
Yes.
Any dispute relating to the validity of the election of the president and the vice president of the Gao Panchayat under this act shall be decided by the deputy commissioner. Absolute power is there, my lord. Section 11, for which, my lord, the earlier round of litigation, honorable single judge has referred the matter to the deputy commissioner in the light of section 11. And after perusal of the video recording, my lord, as I have shown, my lord, page 27 of the modality, that vote cannot be 5. They are 4. And that prima facie found corroborated.
Yes, who's for the state? Anyone? Would like to have a look at the records. Contentious issues. What is the position now?
My lord, I have taken charge. I have taken charge, my lord. They have, it is the order of 27/8, my lord. By this time, I have taken charge.
When did you take charge?
Charge, my lord, yesterday I have taken charge. Some copies have been given to me. That observation be written, my lord. My statement be recorded, my lord.
Heard 3.
Lord, we have made a specific statement that nobody has taken charge.
I have taken charge, my lord. My revision be written.
I heard 3 K.N. Chaudhary, Learned Senior Counsel assisted by Shri S.K. Talukdar for the
27.
petitioner.
Sorry, my lord. After 27, we have taken charge. After 27/8, my lord. Immediately after MP order.
Well, we have filed the writ petition yesterday, my lord, and paragraph 9, we have made a statement. Because earlier I was given charge after the election. Para 9, page 11, my lord. And the last page of the, my lord, page 47, we are operating the bank account also. Yesterday it was filed, my lord. It is stated that till that no action has been taken by respondent in terms of the impugned order dated
I have the instruction, my lord, immediately after the order. We have taken.
The petitioner has put to challenge an order dated 27/8/2025 passed by the District Commissioner Sri Bhumi in a dispute raised by the respondent number 6 regarding the election of the petitioner as the president of the Umarpur Gao Panchayat in the district of Sri Bhumi. Full stop. The said order was passed in a proceeding which was initiated pursuant to an order dated 21/7/2025 passed by this court in WPC 3922 of 2025. Para. Briefly stated, the elections of the aforesaid Gao Panchayat was held and the first meeting was convened on 3/7/2025. It is the case of the petitioner that both the petitioner and the respondent number 6 had secured 5 votes in the contest for president, and the same was resolved by toss of a coin in which the petitioner had won. The said aspect was the subject matter of challenge in a writ petition WPC 3922 of 2025 instituted by the present respondent number 6, which culminated in an order dated 21/7/2025, whereby the district commissioner was directed to resolve the dispute full stop. By the impugned order dated 27/8/2025, the respondent number 6 has been declared to be the president of the said Gaon Panchayat para. Sri Chaudhary, the learned senior counsel, has submitted that in the situation where two candidates get the equal number of votes, there is a provision in the Assam Panchayat
Rule 45.
rules, namely Rule 45, to go for a toss of coin. And the record would show that the respondent number 6 had consented to such a procedure being adopted. Full stop. He has submitted that after such acquiescence by the respondent number 6, the the district commissioner could not have gone to the other aspects of the matter. Full stop. He has otherwise also contended that though one vote has been doubted, as per the valid ballot paper sample, such votes are to be regarded as valid votes. Para. On the other hand, Sri G.I. Borbhuya, learned counsel for the respondent number 6, has submitted that the voting for the post of president had resulted not in a conclusion of receiving equal number of votes, but it was 5:4 in favor of the respondent number 6. Full stop. However, by manipulation, the votes were declared to be equal, which led to tossing of the coin. Full stop. He has also alleged that even in the said toss of coin, there was manipulation. And all these factors were taken into consideration by the district commissioner, who has examined the matter pursuant to the directions of this court, and accordingly, the order dated 27/8/2025 is a valid order. Full stop. Para. Let notice be issued, returnable by 4 weeks. 3 K Kwar, you appear as what? AG or what?
I'm appearing as a standing counsel for respondent number 1
Standing counsel PNRD accepts notice on behalf of respondent 1, 2,
and 4.
4. Whereas we H. Sharma, learned edition, senior government for
3 and 5.
3 and 5. You are for 6?
My lord, I am for the 6. My lord, one more thing to be clarified. When I accept finance, all the power have been given to us.
Sri J.I. Borbhuya accepts notice on behalf of respondent number 6. That extra copies be served upon the learned counsel for the respondents. Para. Sri Chaudhary, the learned senior counsel, prays for an interim order. Full stop. He has submitted that the aspect of the validity of votes could not have been gone into by the district commissioner, and the resolution which was to be done was only to be confined to the aspect of the toss, the procedure for toss adopted as the number of votes secured were equal. Full stop. He has also submitted that the petitioner was the newly elected president and had taken charge. Full stop. Para. On the other hand, Sri J.I. Borbhuya, learned counsel for the respondent number 6, has submitted that immediately after passing of the impugned order dated 27/8/2025, the charge has been handed over to his client, except the financial aspect. Full stop. Para. Considering the above, this court directs that status quo as on today be maintained. Full stop. Let the records pertaining to the order dated 27/8/2025 be produced on the next date, when an endeavor would be made to dispose of the requisition.
Deep lovely.
You can take this back.
Milord.
Give it to the above, yeah? The above, yeah? In respect of an order dated 27/8/2025 passed by the District Commissioner State Government, caveat would be heard in the event, so caveat stands in charge. Okay. পানিও আনিব দিব না এখন
Made pleasure launch. আচ্ছা তো আই এখন কার কতদিন স্টার্ট করা হ্যাঁ
Yes.
Milord, by my learned friends, I therefore whether I will start or he will start. Or I can also start, Milord.
We'll try to resolve on the 17B aspect only.
Yes, yes. Milord, if it is the fact, Milord, if your lordship would kindly have this IA, Milord, 1433, because in terms of 17B, Milord, they are to file an affidavit.
Yes.
They have not filed any affidavit. They have filed an affidavit that it is not, Milord, notarized. Can you see, Milord? Page number 1433
of
IA, Milord. IA number 1433 of 2025. Page 8 is the affidavit, Milord. It's not notarized.
Page 8.
Page 8 and 9.
It is notarized.
No, Milord. 8 and 9?
Notarized.
No, Milord.
Yes, kindly see the court slip.
The one has been given to us, it bears nothing, Milord. The one before your lordship is yes, Milord, but the one given to us. First page to some, second page to. The one given to us is not. Anyway, I don't. No, we thought it is not there. It is a 9. Anyway.
You should give a photocopy of the same copies you filed, Mr. Mazumdar.
Normally he should file, but he has not.
Photocopies, not original. Photocopies will be enough.
Yes, yes.
Stamp will be there.
Anyway, my lord, now my lord, only point which your lordship will have to take a call regarding 17B is, my lord, if your lordship would kindly come to 33C for a moment.
Just a minute, please. Yes.
If your lordship would kindly come to 17B itself, my lord.
B.
Yes. Where in any case, a labor court, tribunal or national tribunal by its award directs reinstatement of any workman and the employer prefers any proceeding. His employer has not, we are not his employer. We have not initiated any proceeding. That's the problem. There is no master-servant relationship. And the employer prefers any proceeding. The employer is Supermax. The respondent number 3. Which fact they acknowledge before the labor court also. And in the execution proceeding also, Miller, which they filed, subsequently they withdrew. Going by the Miller, otherwise, had we been employer, Miller, there is hardly any scope of any argument. We are bound to give him the last drawn ways.
How did you step into the shoes of Supermax?
No, Miller. Supermax stepped into our shoes.
Oh, Supermax is.
Yes. Now, if your lordship would kindly come to page number.
How did
yes.
what is the mode of Supermax coming into your shoes?
Because that the company itself was purchased by them. There was a transfer BTA, Miller. That's what I'm trying to show, Miller.
Yes.
If your lordship would kindly come to page number 41, it starts at 25.
Of which
Miller, page 25 is the business transfer agreement.
Of the petition.
Yes.
25.
Yes. Business transfer agreement between Vidyut Metallics Private Limited and Supermax Personal Care Private Limited. Now, Supermax is respondent number 3, Miller. Now, please come to 41. 6.2.3. The transferee shall, on and from the transfer date.
46.
41, Miller.
41.
Is para 6.2.3. 6.2.3. The transferee shall, on and from the transfer date, take over all employees of the transferor employed for the purpose of business with continuity of service on conditions of service not less favorable enjoyed by the employees prior to the transfer date, and such service shall be reckoned from the respective dates of employment with the transferor in accordance with the terms of their employment in accordance with the applicable laws. This is important. The transferee shall be responsible for complying with applicable laws in connection with the employment of the employees with effect from the transfer date, and shall pay and be responsible for fulfillment of all liabilities, including but without limitation payment of gratuity bonus under the applicable laws, rules and regulations with effect from the transfer date. Now, my lord, this BTA was accompanied by a disclosure letter, which your lordships will get at page 53. Page 53, my lord. Now, it was communicated by petitioner to the Supermax, and if your lordships would kindly come to page number 74. Amongst others, my lord.
What is the date of this BTA?
30/12/2010. 30th of December 2010, my lord.
2010. 10.
Yes. And if your lordships would now kindly come to page 74, my lord.
74.
Serial number 72. This is the, my lord, application means Labor Court proceeding 6 of 2009. Center for Medical and Sales Representatives Union. There is the Union of the Workmen, my lord. And the liability is also indicated 14,25,000. Now, if your lordships would kindly
This
come
application
to,
6 of 2009 pertains to the dispute.
yes,
Labor dispute.
yes, that is the reference, Miller. That is the reference case.
And the amount involved is also been
Yes,
indicated.
quantified. Now, what the Milord union did, Milord, that is the petition respondent number 2, 3. Milord, they filed an application under section 11(9) at page 132.
For execution.
Yes.
On page 132.
Yes. No, this is our reply. They reply by Supermax. In fact, my lord, in this proceeding, we were not made parties. Supermax was made parties. Now, this is an application filed by Milord. They describe themselves as judgment debtor. At page 132, they filed this miscase in the execution proceeding, where they say,
No, judgment debtor, decree holder, they say.
no, Milord, management of Supermax is the judgment debtor.
No, who has filed this? Supermax has filed.
Execution was filed by the decree holder.
Oh, a decree holder, they have.
Yes. No, Milord, this application was filed by judgment debtor. Anyway, Milord, let us not go to that dispute, but this is an app where, Milord, in this application filed for execution, Supermax was made a party, we were not made a party. Because they knew it.
Now, why did Supermax file this application?
Now, they say, Milord, we are not necessary parties, therefore our name should be deleted.
Supermax is not a necessary party.
No, they say at page 140, the prayer, this IA was filed in the execution proceedings. Page 140.
Yes.
In the premises, it is most respectfully prayed that your lordships may graciously be pleased to admit this petition, and upon hearing the parties be pleased to pass an order that award dated 28/1/14 passed by the learned Labour Court in reference case number 6 of 2009 is not binding upon the petitioner company, and also implement of the petitioner company in the present execution proceeding is bad and not pleased to pass. Anyway, their prayer is that we are not necessary party, why have you made us party? So, well, from the point of view of Milord, the decree holder, there was no dispute. They knew that Supermax is the person. That's why they filed the execution against them. Thereafter, Milord, what happened? The union withdrew the Milord application, that execution proceeding, which was permitted by the Milord learned District Judge Guwahati.
Yes.
Thereafter, Milord, they instituted this 33C2 process. That is how we are before your lordship. Milord, my only submission is, Milord, the records of the Labour Court reference case number 6 of 2009 would reveal the actual picture, Milord. Because since those records are not there, we are also at a difficulty. So, therefore, there are two
records were called for.
Oh, I can get record to 9 record call for Kursia. And in the execution proceeding, Milord, Labour Court. Even before Labour Court also, Milord, they have annexed documents which we are having certified copy, whereby, Milord, they have sought to general conduct on the code of conduct.
Records have not been called for.
Not, that is the difficulty. My lord, my learned friend's client has waited for quite some time. From 2014, the award. Another 2 weeks time, my lord, if your lordship kindly satisfies lordships with the records, then lordship pass an order, my lord. My true contention is, my lord, I am not the employer. And section 17 mandate speaks of an employer preferring a petition. Employer has not preferred a petition. That is the point to be gone into.
Is the execution case on record? Can we have a look at the execution?
No, my lord. That is also execution case to go to. No, my lord, that is not before. That's why I say, my lord.
We only have that application for withdrawal.
Yes.
By Supermax.
Yes. The original record, if it is called for, my lord, then everything will be clear. And their petition under section 11(9).
42.
Their withdrawal petition is also there, but my lord, that original 11-9 petition is not there.
Where is that serial number just, you know, shown in the,
Regarding my lord, their liability, my lord.
yes, no, regarding this present case. Yes, 72, 72.
74.
Yes, yes.
Page 74.
72.
Serial number 72.
At page
Amongst
50
others, my lord.
At page 53. I think.
Yes. It starts at page 53 and
That's
the
72.
page 74 is the my lord relevant page and serial number 72.
Yes, yes.
And my lord, if your lordship would kindly come to page 72, schedule for VMPL contingent litigation liabilities, which was taken over by Supermax. It is not our intention that the benefits should not go, my lord, but only thing is.
I come to page 143.
Yes.
Please. It is a part of their withdrawal application.
Yes,
under
this was their application,
order
seeking
to-
withdrawal of the,
Order 22, Rule 1.
yes.
Please come to paragraph 4 at 143.
Yes, during pendency of the instant proceeding, judgment debtor has brought the aforesaid business transfer agreement dated so and so into record, wherefrom it has been learned that Violate is still in existence and it has transferred some of its business to management of so and so, but it is clear from the said agreement that liability of any judgment, decree of court cases are not transferred to the management of, this is not correct.
This is not correct.
Absolutely not correct.
First, certain important point raised by the learned senior friend that I am.
If you want some water, we can give.
That the management, that is the petitioner, is not the employer. Lordship may come to the page number 115.
115.
115, paragraph number 5. It is an award passed to the labor board. Lordship, I am reading out the paragraph number 5.
Yes.
The management side to substantiate their plea adduced evidence of MW1 Sri Biswajit Bose, MW2 Sri Subhash Datta Chaudhary, MW3 Sri Suman Sarkar. They are also exhibited various documents to substantiate the fact. They have exhibited service rule by the Exhibit M. They have also exhibited the appointment letter of Sanjay Kumar Dhar, Vidhu Sarkar, that is the true applicant who have filed the application under section 17B. And some other Mukti Kundu by the Exhibit A, B, and C.
Mr. Mazumdar, why did you institute the execution case against Supermax?
Lordship, I'll answer all the queries of
No, you have to answer that first. That means you knew that Supermax was on the fray.
Lordship, these are the development after passing the award. So first, before passing the award, of course not. because
No,
I can go for execution.
After passing of the.
After passing
no,
the award.
During the execution, you had filed an execution.
I will address because these are the two separate proceedings. They have amalgamated in a single writ petition. So I'll have to address the separately. So one award is passed by the labor court and the execution process was different. It was filed in the execution court. So I will address
No,
first.
execution court, you had approached the execution court. Why did you bring in Supermax? You knew that Supermax was in the fray.
No.
Then why did you
that,
make
that
parties?
part, Lordship, that part I will address.
No, address that part first.
Because that the award was passed against the management who is the writ petitioner.
Yes.
Right. So normally what happened, if I go for the execution, I must go against the execution of the award of the management.
Yes.
But it was my wrong step. That is why I have.
No, that is what. How did Supermax come into your mind?
That is a wrong step. I have done a mistake.
No, from where it came to your mind that you knew that Supermax was there in the picture?
There was a suggestion from the different corner that some cases were that they have annexed also in the writ petition. Some cases were decided by the Labor Court of Maharashtra, Mumbai, so that somebody suggested me. But this is not at all a legal issue to decide my case. Lordship, I will keep my submission within the four corner of the law.
No, see, one point has been raised that it is qua an employer. Now the award was passed in the name of the present writ petitioner.
Right.
That we know.
Yes.
But at the same time, they have brought on record the business transfer agreement of 2010, which is prior to the award. Award is a 14, I think.
Exactly. Lord.
Now, the question is that BTA was there, and you also knew that there was a involvement of Supermax. You proceeded
No,
against.
that was I did not know, Lordship.
Then why did you proceed against Supermax then? You did not know.
Lordship, this one after one, Lordship.
Yes.
Let me satisfy the court first, and I will be confused if the two issues are amalgamated.
Yes.
That first.
There is nothing to be confused.
No,
Is it such a confusing situation?
first.
It's your case. You are as if alleging the court that you are putting different facts into
No, Lordship,
it's your case. You should be the master of your facts.
That is why
We
I
have just heard Mr. Chaudhary for 2 minutes.
I'll address all the queries of the court. First, the matter is decided in 2014.
Yes.
3 of the director of the management company appeared before the labor court, adduced evidence. None of them raised the issue about the BTA. They admitted me workman as their employee. They have contested the case, admitting that workman is their employee. At that time, the BTA was never raised in the labor court. But when the award is decided against them, they are come up with the BTA that this award is not binding on us. That is why it is binding on the Supermax. So this issue could be raised in the labor court itself. And before answering my question, Lordship, it is the responsibility of the writ petitioner that why the BTA was not introduced in the labor court. Because the director of the companies appeared before the labor court. And second thing is that, Lordship, that the documents which is not adduced before the labor court, Lordship, one thing is clear that Lordship is, although the petition is filed under Article 2 to 6, but Lordship is treated the petition as under Article 2 to 7 as per the Guwahati High Court rule. So Lordship is exercising the supervisory jurisdiction.
Where have we stated so?
But
where have we stated so that it is not 26?
Rule is there, Lordship.
No, is it is it presented under 227?
It is under 226, but Lordship, as per the Guwahati High Court Superintendent's Tribunal Rule 1992, that the award passed by the labor court challenging the writ petition award passed by the labor court shall be filed under Article 2 to 7. So
we treat this as writ petition. We don't exercise supervisory jurisdiction in awards of labor court.
The writ petition under what provision of law?
226.
But rule is there. Rule says that 2 to 7. High Court rule. It is not my submission, Lordship. High Court, Superintendence of High Court Tribunal Rule 1992.
Let us see, there's rules, we'll examine the rules, but awards of labor court are, you can put to challenge
No,
under 226.
there is an interesting development. Let me share, Lordship.
Yes.
My friend knows, not senior friend, he knows that there is certain, it is in fact my petition. When I prefer an appeal
when the decision was against me by this single judge, honorable single judge, then in the division bench raised question, no, intercourt appeal is not maintainable because it is a petition decided under Article 227. And these are a series of petition pending in the division bench.
Answered, already answered?
No, pending.
Not answered.
Not answered. So that is why, as long as the rule is functional, so Lordship, if I am not wrong, then Lordship will treat the petition as under Article 227.
Let's see what High Court rules. Which one? Rule?
It is a Guwahati High Court Superintendence of Tribunal Rules 1992, page 350.
Pay, no, rules or what? Guwahati High Court. Which book are you having? Same book, yes, same book, I think. Page
350, Lord.
350. Yes. Of tribunal's rule. This is a award by what? A tribunal?
Labor Court.
What is the difference between labor court and an industrial?
Tribunal, labor court is there, Lordship, also in the city.
No, what is the difference between industrial court, industrial tribunal and labor court?
Some cases which are fall under the industrial tribunal.
Yes.
Because if something is come under the definition of industry, full-fledged industry, then the authority refer it to the industrial tribunal. And if it is purely an industrial dispute, that is the dispute regarding the personal right of the workman. And although he may not work in the industry, then the matter they refer to the labor court.
Where is labor court mentioned here?
In the schedule, first one.
Yes, labor court, industrial tribunal, motor exchange tribunal. Okay. No, the power of superintendence is not doubted. But what do they invoke? Is it required that they have to invoke 227? These rules are for what?
Not,
I have superintendence of tribunal's rules. Does it lays down that award has to be challenged only by way of 227?
No. Lordship may treat it. It is up to the discretion of the court. I am not on that. I am telling that when the scope of the judicial.
No, this is a very interesting question. Because these rules you have placed reliance upon, these rules are only for, it's called the Guwahati High Court Superintendence of Tribunal Rules. And what is the purpose? Kindly see 4 and 5. The tribunals are to submit returns to every, tribunal shall submit to the High Court returns in every forms as may be prescribed, number 1. Then for the purpose of efficient and speedy disposal of cases, High Court may from time to time notify the quantum. It is not with regard to a challenge of an award. It is only with regard to superintending working of a tribunal, a labor court, a motor accident tribunal. This is not with the procedure of challenging.
Yeah, Lordship, I am not.
No, we have to understand that is why.
No, that is the division bench.
That's an interesting question that we'll like to.
Division bench raised the question that the intercourt appeal is not maintainable, as because.
Yes, if it is 227, there is no intercourt appeal. It's a revision. But if it is 226, intercourt appeal will be there. It's a latest patent.
At least 15 writ appeals are pending for adjudication in.
Not answered.
Not answered. So, Lordship, the scope of the judicial review, what I'm submitting that that Lordship will consider that if there is a irregularity, irrationality, or jurisdictional error, or whether the admissible documents whether any inadmissible document appreciated by the labor court or not. These are the judicial scope. Because the lordship is.
No, Mr. Mazumdar, these submissions of yours would be relevant if we are adjudicating the main writ petition. We are trying to consider your application under
Under
17B.
section 17.
17B, they have made a preliminary contention that though they had contested the proceedings before the labor court, in the meantime, there was a BTA by which the entire management was shifted to Supermax. And they have, that is what we have tried to.
But they did not raise the question. In the
Yes, that you are correct. And in page 74, there is a specific reference to this particular case, not only the reference case 6 of 2009, but also the quantum involved. So it's a part of the transfer. And probably you had rightly proceeded against them in the execution proceeding. But because of their resistance or whatever, you withdraw the proceedings.
I am lordship on the that the factual metrics shall be decided at the time of when lordship will hear the writ petition. But the section 17B clearly says that if the employer prefers any proceedings, then I am entitled. And the paragraph 115. So page 115, paragraph 5 clearly says that the director of the company who appeared before the tribunal and examined themselves as a MW, they admitted that I am their employee. And they have contested the reference, admitting that the workman is their employee. And they are.
It was a reference, section 10 reference.
Yes.
Let us see the reference.
Probably the reference is not a part of.
Page 111 in the judge award.
Triple one. It was, I think, referenced by the union, not by a two-way reference.
No, lordship, the reference is always done by the Labor Welfare Department to the government of Assam. The union may raise the industrial dispute only.
No, there are the cases of two-way also. It's not like that.
Union has a state detail.
Individual can also come to the labor court under two-way.
Yes, union, but there are two different provisions. Section 2A, someone may directly approach to the labor court.
Yes, under certain circumstances.
Yes,
but this is a duly constituted reference by the state.
Yes.
Now, the management do it, okay. Reference was done in 2009, when the BTA was not in existence. Oh, that is
right. But that decided in 2014, in between the BTA came into existence in 2010, and the director appeared in the labor court when the BTA came into existence. But this, lordship, the simple understanding, lordship, admitted position is that I am their employee and they are my employee.
Mr. Chaudhary, where does the labor, this workman goes?
My lord,
I
fully appreciate, my lord. Only thing is, my lord, if your lordship calls for the record of the labor code, in any case, lordship will examine it. Kindly refer this consideration as 17B till the records are received, when more facts will appear. I'm only making that.
He is neither here nor there.
My learned friend's client
He initiated execution. He initiated execution maybe against the proper person, but due to some wrong advice, he withdrew.
Even not on that also.
33 seat to his
The lordship will call for the record and lordship will satisfy yourself, my lord, regarding the otherwise. Then lordship will.
But he may be right in contending that in the proceeding of the labor code, you never disclose about the BTA.
Correct. Actually, my lord.
Where does he go?
In fact, my lord, they have brought on some records that will show, my lord, they were aware. That's what I'm saying. My lord, some hostile directors have done that. Para 8 and 9 have made that statement.
Their knowledge is, it's revealed by their execution case against Supermax. That is, whether it's by mistake or so, they knew about Supermax. But at the same time, it was your duty to reveal that in the meantime, BTA is there. Either get Supermax on board or you discharge us.
Maybe lordship will pass the same very order. Only thing is, lordship will kindly call for the records. In any case, records should be called for. After 10 days,
Supermax is a party here. Supermax is a party here.
Yes. Supermax is a party.
Served.
No, they have not been served. Service one. We have again taken steps.
Oh, respond number?
3. Or we may be permitted to take Dusty also, my lord.
You have Supermax on board. We cannot leave his plans like this.
No, certainly.
Suffering since 2014.
Absolutely. There can be no manner of doubt about it.
And the award has attained finality. There is no challenge, at least till now.
Correct.
23 only had put to challenge.
No, correct me. Only when we came to know, my lord.
Your lordship, if the award is not binding on anybody,
No, it has to be.
No,
made
it
by-
has to be known.
No, that we are not, we cannot leave this award like this.
Court is trying to protect your client's interest, even will protect your client's interest. That's not the issue. Question is, legally it has to be sustainable.
We do one thing, we'll consider this. We get the records of the labor court
Yes.
and we
And
permit
permit
you
us to take justice, my lord.
you serve this, and
Yes.
if they do not appear, it will be to their own peril.
Yes.
And in the 33 C2 proceedings, who are the parties?
they are the party
Only.
only.
In one, they made perfect party.
Well, lordship, this is the fact that I must submit. The workman who has been advised by someone.
Yes, we understand.
Then he
We
has been
understand the
again
predicament. You may not be so much aware who's, but you have instituted 33 C2. Okay. Heard. Sri K. Chaudhary, Leonard Sinek. For a dispute between you and Supermax, they should not suffer.
Yes.
That is, we'll have
No,
to.
absolutely.
Ultimately, they are suffering. How much is the quantum? How many of you are there? 3?
Two.
2. What is the amount involved?
20,000 per month. That is, if they give us the last own salary, it will be 20,000 per month.
For since 2004, 14.
No, from the date of the passing of the award from 2014.
14?
14.
More than 10 years. More than 10 years.
11 years, my lord.
More than 10 years.
11 into 40 hole, 44 lakh. Will be about 44 lakhs.
Heard Sri K. and Chaudhary, Leonard Senior Counsel, assisted by Sri F. Chakraborty for the writ petitioner. Also heard Sri F. Z. Mazumdar, Leonard Counsel for the respond number. Respond numbers?
4 and 5.
4 and 5. Who has also filed I 1433. And what is 1342? Both separately or what?
Yes, separately.
Both 17B.
Both 17.
Who has filed I is 1342 25 and 1433 25. Full stop. Para? Three. Chaudhary, the Leonard Senior Counsel, has submitted that the provisions of Section 17B of the Industrial Disputes Act would come into operation for the employer, full stop. He has submitted that though the proceedings before the Learned Labor Court in reference case number 6 of 2009 was in the name of his client, comma, in between wide a business transfer agreement dated 30/12/2010, the business was transferred to Supermax so-and-so, respond number 4.
3 million.
3, full stop. He has specifically drawn the attention of this court to the list appended to the said BTA, and again serial number 72, there is specific reference, a specific mention about the present reference case, full stop. He has also submitted that initially the private respondents 4 and 5 had instituted an execution proceeding against Supermax, bracket respond number 3, which was, however, withdrawn, and thereafter the application under section 33 within bracket C within bracket 2 of the Industrial Disputes Act 1947 was instituted. Full stop. He has submitted that unless the aspect of the employer in inverted comma is determined, comma, there may not be a case for application of 17B of the Act. Full stop, para. On the other hand, Sri Mazumdar, the learned counsel for the contesting respondents 4 and 5, has submitted that the proceeding before the learned labor code had culminated in the award dated so and so 2014 keeper. And in the said proceeding, though the officers of the present petitioners were examined, there was no reference to any such business transfer agreement said to have been executed in the year 2010. Full stop. He has also submitted that by mistake, that on incorrect advice, the execution case was filed against the respondent number 3, which was withdrawn, followed by the petition under section 33 within bracket C within bracket 2 of the ID Act. Full stop. He submits that due to certain disputes between the petitioner and the respondent number 3, comma, his clients cannot suffer, and this award was passed in the year 2014 and more than a decade has elapsed. Para. Without commenting on without expressing any opinion on the submissions made by the learned counsel for the parties, this court is of the view that the records of the learned labor court would be required to be perused. Full stop. This court has also noted that that Supermax so and so has been made respondent number 3. Until now, the service is not complete. Full stop. This court directs the petitioner to take dusty service upon the respondent number 3 so that appropriate orders may be passed in this proceeding, which may affect the rights of the said respondent number 3 also. Such dusty is to be routed through the registry of this court, in which and in any notice, date. You have to file an affidavit also. We have a date fixed.
Yes, sir.
List this case
The court is.
on when?
Any date convenient, but.
We'll have it on either on 16th of October or 14th of October, immediately on the
Let it be 16.
16th of October, registry to give registry to requisition the records from the learned labor code, Guwahati.
Yes.
Guwahati.
The earlier part of the order, Lordship has said that the execution was filed by respondent number 4 and 5. No, it was filed by respondent number 2 union.
Okay, by the respondent number 2 union.
Diploma.
In this case, my lord, I have filed in one I am for the respondent number 7 to 11. My lord, I have filed an I that has not come. Let it come along with that I.
I for
dismissal of the case, because there are subsequent developments, some subsequent development took place, and
I for dismissal of the case.
Yes. In this case, I am the.
You may not file I, you can simply say that dismiss the case. We'll happily dismiss it. Why do you take the pain to file IA for dismissal?
Dismissal is not the subsequent here.
IA for dismissal under what provision of law?
Yes, no, well, in this case, they have paid for implementation of the certain order, but that order does not exist now.
Yes.
My lord, actually the matter fixed today for appraisal of the action taken by the GMC authority, my lord.
But if the order is not existing.
My lord, in this regard, I have objection that in the IA,
Have you been served with a copy of the IA?
yes,
Yes,
my lord.
already
You filed
started.
objection to the
Yes,
IA?
sir.
Okay.
That I, my lord, serial number 115.
When did you file?
It
Today?
was one filed 23rd 9, day before it started.
Or 3/9?
Yes, 3/9.
Okay.
Let it come.
Your MSECA,
Yes, my lord.
heard 3 MSECA learned counsel for the petitioner. Also heard 3 P. Upadhyay learned counsel for the respondent number 7, 8, 9, and 10, who has informed that an IA has been filed in this case on 3/9/2025, which has not been listed. Full stop para. List this case along with the IA. When? On?
Any day.
On Wednesday next.
Wednesday.
Wednesday.
No,
Huh?
Friday, man.
Friday.
Friday.
Friday is closed.
Friday. Better.
Friday is closed. Better? How is it better? You may come, will not come.
Friday, my lord. Then thereafter, I'm taking some treatment.
Yes, Mr. Saikat, a date, please.
Let it be on 16th.
16th.
On 17th.
17th. Obliged.
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 May I please, Your Lordship?
Yes, what is this?
Lordship, please kindly peruse the order dated 28/7/25.
28/7.
Yes, my lord.
Inquiry has submitted that on a natural register. Yes, report
Yes, lordship.
you have got. Okay. His name is there.
No, lordship.
He's not there.
In our affidavit, lordship, your lordship may kindly peruse our affidavit filed by the.
Then how do you claim?
Yes, lordship.
My lord,
And he has alleged that some of the private respondents they are getting and they have got pakka houses. I have 170. This is the voluminous record, lordship. Even then, I'm trying to find it out. According to my learned friend, 2 persons have already got. I have searched their name. Their photographs are also there. The condition of the houses, lordship, all are thatched houses demolished.
What had happened? Some storm.
Storm. They are asking for some relief granted by the state government who are affected by storms.
But your affidavit is that they did not suffer the loss.
Lordship, 2 petitioners suffered and they are getting the.
How many of you are there?
total 45 petitioners are there. They submit that out of 45, 2 petitioners name enlisted in the
Yes, yes.
beneficiary list. My lord, on 16.
And the storm occurred in the year 2022.
2020.
Now, lordship, it cannot be even.
Okay. My lord, the fact of the case is that 16/4/2022, the storm has happened and the report was prepared by that circle officer, jurisdictional Latmandal and the Gavura and some other person like private respondent, my lord. My lord, in the incident, my lord, the petitioner's houses were brutally damaged. And when the survey was happened, they thought they will got the fund. But after a year, after many times, they found out that their name has not been in the beneficiary list. They filed RTI and from RTI, they got the beneficiary list. From that, they got to know that their name has not been in that list. So they filed the representation before the then Deputy Commissioner of Nagaon. But no action were taken. After filing the representation, my lord, the private respondent threatened the petitioner to withdraw the representation.
And
Threatened.
when the petitioner refused to withdraw, then some altercation was happened between the private respondent and the petitioners. And then the petitioners filed an FIR before superintendent of police. But the office of the superintendent refused to take the FIR. That's why the petitioner come to this Honorable High Court.
See, on the second part of your allegation, refusal, that's a different part. First
Okay,
part
okay. Yes, my lord.
is factually disputed by the state.
My lord, main dispute is that this is true that our houses were brutally damaged.
No, that is your contention.
Yes, our contention. The survey conducted by the circle officer, Lakshmandal and Gaubura. My lord, in that beneficiary list, some respondents are there. The near relative and family member of Gaubura and the school teacher whose house were not damaged, they got the fund. Now, my lord, in
No,
this
these allegations are in the realm of factual disputes. How do you determine? You may be correct.
yes,
You may be correct. How do you determine?
my
We
lord,
don't
I'm
have the scope of adducing evidence
my lord,
here.
I'm coming to the next part, determination.
Yes.
part. My lord, in the survey, GPS track photograph are there in this report. If we examine this report, whose house they took photo, the private respondent took photo in front of,
Yes.
so we can it will be clear whose house. But it is true that the petitioner's house was brutally damaged.
What do you say? Where their house is damaged?
According to us, according to us, from our affidavit, which is not rebutted by them, they put two petitioners, petitioner number 23 and 44, their houses
Difficult.
were
What is your
damaged.
name? Your name? Your name?
K. Islam, my lord.
Mr. Islam, it will be difficult. Factual, if there is
My lord,
dispute, it will be difficult for
primary
report.
prayer. Now my prayer is that if re-examine the photograph, my lord, GPS track photograph, it will be clear, my lord.
Then Mr. Sharma says that you have not even filed rejoinder affidavit.
No, it was not been rebutted, Lordship. It was never been rebutted by them.
Who are you?
I have a private respondent 7 to 12, my lord. Only two respondents, they have received the benefit, my lord.
Who are you? 7 to 12 means?
According to them, they are the beneficiaries. And according to him, two respondents, private respondents, they have received the amount because of that damage done by the storm.
How
And
many of
from
you are
him,
there? How many of you?
My lord.
You are how many?
We are-
You represent how many?
7 to 12.
6 to
7 to
12.
12.
7 to 12.
My lord.
Out of them, two have,
Yes, yes.
not all
Not-
5.
My lord,
And
in the
from
previous
him, Lordship, I have find it out from the record, the photographs, it is seen that it was totally, thatched house totally damaged. So other parts there are disputed question of facts.
okay, my lord. My lord, previously, the private respondent admit that all the private respondent got the fund. After I am filing the photograph of the two respondent, I got the,
Previously, they admitted what? That they got the fund. Where? Where is the admission?
my lord. An additional affidavit filed by the petitioner number.
By the petitioner.
Yes, my lord.
Additional affidavit.
Additional affidavit, my lord. Page 48.
Yes.
After I filed this affidavit, my lord, in number 1 Kandulimari village, there
Not
were
48,
no
what is-
Pakka house were fully damaged.
These are photographs.
Not
How?
48.
My lord,
Which page? Which page?
my lord, 48, my lord.
Not
Two Pakka houses are there.
Not 48.
Additional affidavit filed by the petitioner number 1.
এইবিলাক গণ্ডগোল কৰি দিয়ে। কাটিব কিয় লাগে মই বুজিয়ে নাপাওঁ। যোনটো দিছে দিছে। Additional, no? 70, 20. Yes, what is this?
My lord, in there, two Pakka houses, petition on respondent number 11, 9 and 11.
Yes.
My lord, in number one Kandulimari, according to report prepared by the circle officer, of affidavit in opposition filed by the respondent number 5. In that, they annex the report, storm report, where in the number one Kandulimari, my lord, there is no Pakka houses were damaged, 0. And the respondent number, I got 2 respondent numbers, they have, and the petitioner, when I discussed with petitioner, they said that all the respondent have Pakka houses, no Katsa house, they were not any Katsa houses. Now the question is that, my lord, if they are having Pakka houses, and in the report, my lord, their Pakka houses were not damaged, how can they get the fund? And my lord, the fund they got is the fully damaged Kacha houses amount, my lord. My lord, the respondent got, it means someone must be deprived, my lord. And my lord,
No,
this,
these are the houses
this
of respondent
respondent,
number
my lord, this
nine.
respondent,
These are the houses of respondent 9 and 11.
yes,
This is
I
your,
got only 2 photographs.
This is your projection. What is there? What is, have you admitted?
I haven't seen the house of respondent number 9 and 11, my lord.
Page 82. 82.
According to him, 11 has not got any.
11, my lord, is not received, my lord.
Oh,
11,
9 received, my lord.
9 and 12 received.
9 and 12 received, my lord.
This is 11, so 11 goes lordship, 9 itu tumalogor pasagon na pagagor. Recent photograph. Recent photograph.
Is it recent photograph, my lord?
Yes,
Is it
in the year 2023. They take the photograph.
2022, my lord. And now it is our, please, my lord, we have Katsa house, my lord.
My lord,
Nobody should get a windfall if no damage has taken place. How should you get any amount?
my lord, the respondent number 11 is the father of respondent number 12. He is a school teacher. Respondent number 11 is a school teacher, and Sharif Ansari, respondent number 2, is the son of respondent number 11. They
It's
staying
not
in
in a
Pakka
writ
house.
proceeding unless there are questions of fact which are admitted. Difficult to.
My lord, if the photographers are GPS tech photograph, my lord. If this photograph were examined, the fact will clear.
Now,
Whether they
when was the storm? Storm was in 2022.
Yes, my lord. Now
You are unnecessarily pursuing this litigation here.
My lord,
You should go to a civil court. What will you get here?
my lord, if I am standing here, my lord, the GPS tech the same place.
You have to, these are
It
matters
is not
which,
22 or 25, my lord.
these are matters which will require evidence.
My lord,
It will require
as
adducing
we are
of
the victim,
evidence.
my lord. As we are the victim. When the survey was happened, we have faith on the circle office that we will got. That's why there is no requirement.
All this
to take
faith and
the-
everything has to be established, has to be demonstrated in the court of law. How do you establish in a writ court? There is no avenue of adducing evidence.
Yes,
You have to
my
adduce evidence, stand on the dock, cross-examination, then it will be admissible evidence. Here, if it is disputed, how do you proceed? If there was no dispute, there would not have been any difficulty. And Mr. Sharma says you are not even rebutted.
My lord, in the report submitted by the circle office, it is clear that in that village, my lord, there are no pakka houses were damaged. Though the respondents got the fund, my lord, the petitioner's house, Katsa house were damaged, but they are not getting the fund, my lord. My submission is that, my lord.
Heard.
Now, my lord, what is my submission is that the circle, the deputy commissioner was not taken any step when we immediately we filed the representation. And the ASP, the superintendent of police also not took action against the respondent when we filed the FIR. So there must be something, my lord, inside. My lord.
What about the FIR part?
That is not their prayer, Lordship, here.
Huh?
In the main petition, my lord, we annex the.
That's the relief paid for. Oh, where? 15 page 15, where, Mr. Islam?
Yes, my lord.
That is no, there is no such prayer, Lordship. I have no knowledge about that affair. There is no such petition before your Lordship regarding that also.
My lord, when the petitioner went to the SP office.
You have to state before us. Oral statement will not do, Mr. Islam. There has to be a prayer specific.
My lord,
You cannot waste the time of the court like this. We thought you had a prayer, valid prayer. Why should you put a question? How do they rebut your submission if it is not in the pleadings?
My lord, when I filed this writ petition is that, my lord, the district commissioner.
We proceed on a structured basis. There has to be something before us in the form of pleadings.
My lord, in that representation.
I am
my lord,
praying for a
everything
heavy
is-
cost, Lordship. It's a judicial, Lordship. Wastage of judicial time, Lordship. Exemplary cost should be imposed upon.
You cannot
My lord,
make the submission. Those are not supported by pleadings. You said that there is an FIR not acted upon. There is no mention here in the prayer.
My lord, my prayer in this petition is that the district commissioner has not taken any step. So, my lord, we filed the representation, my lord.
Heard Ricky Islam Learned Council for the petitioner. Petitioners also heard 3.
But it is my humble prayer to direct the district commissioner to inquire the matter, my lord.
Revenue Department, P. Also heard Sri H. Sharma, Learned State Council. Common,
Lordship.
Ms. P.R. Mohanto, Learned Council for the Revenue Department. Finance, anyone? Finance? Finance, Sri B. Gogoi, Learned Council, Finance Department. For some free. Azad, you are Azad?
My
For the small numbers?
7 to 12.
70-12. Full stop. The writ petition has been instituted with the following prayer, page 15. Para. It is the case of the petitioners that they are villagers of which village?
Number 1 Kandulimari.
Number 1 Kandulimari in the district of Nagaon and living in Kacha houses. Full stop. In the year 2022, their houses were destroyed due to a heavy storm and cyclone, and thereafter they had applied for relief from the government. Full stop. It is the contention of the petitioner, allegation of the petitioner, that an inquiry was conducted by certain officials, including the Latmandal and Gaubura, and the actual parties who had suffered loss were deprived, and family members of those officials having RCC houses were given the benefits. Full stop. Specific instance has been made that 10 persons in the family of an ex-Gaubura and a son of a school teacher were also given the fund. And such information was obtained by the petitioners under the RTI Act. Full stop. The petitioners also allege that they were threatened by the private respondents. Full stop. The representation of the petitioners before the district commissioner was also not acted upon. Para. 3. Islam, the Learned Council, has submitted that they are the actual sufferers and are entitled to the relief amount which was given by the government, and there has been misuse of the said scheme. Full stop. Para. Per contra, comma, 3. H. Sharma, the London State Council, has submitted that detailed inquiry was made, and it is only the actual persons who had suffered damage were given the benefit of the relief. He has submitted that though in the present petition allegations have been made against the private respondent number 7 to 12 of receiving the relief amount, comma, it is only 9 and 12. It is only respondent numbers 9 and 12 who has got the relief. Full stop. It is submitted that there is no partiality or unfair means in distribution of the relief which has been done on an assessment of the ground reality.
One more submission, Lordship. The petitioner number 23 and 44. In spite of getting the relief, they have approached this honorable court by suppressing the material facts.
My lord, at the time of filing this writ petition,
He has also
they are
submitted-
not getting
It
the,
should have been brought to the notice of this honorable court, Lordship.
my lord,
It is also submitted that out of the 45 numbers of petitioners, comma, petitioner numbers
23 and 44.
23 and 44 has actually got the relief,
Lordship.
as
yet
they
they are not getting the learned friends
were
previously submitted that
at the time of
their
dictation.
name has in.
Mr.
name-
Islam, if you do not know how to submit, just have a seat. Not at the time of dictating orders.
Pardon.
Got the relief. And this fact has not been brought to the notice of this court in the subsequent affidavit filed. Para. 3. Ajad, the Learned Council, for the respondent numbers 7 to 12, has submitted that the writ petition has been instituted without any bona fide and only to have wrongful gain in with regard to the scheme for granting relief. Para. 3. Islam, the Learned Council, for the petitioners has in his rejoinder submitted that the petitioner number so and so has. Have we got the relief?
My lord, number 23 and 44 yet not get the fund.
Yet
Not getting the fund. Their name has been in the.
that
Lord,
though it is
directly
a
to
fact
the
that
authority to
petition
release
numbers
the fund of.
so and so have been enlisted in the list of beneficiaries, but have not yet got the relief in actual terms. Para. On a perusal of the materials before this court, including the respective pleadings, it is found that the present claim is structured on questions of fact which are disputed by the official respondents. Full stop. It also transpires that though allegations were made against the respondent numbers 5 to 12 by alleging that they have received the relief, comma, it is only the respondent numbers 9 and 12 who has received the relief. Full stop. It clearly appears that the dispute is within the realm of the issue is within the realm of disputed questions of fact, which this court in exercise of its jurisdiction under Article 226 of the Constitution of India may not be able to determine, as the same would require adducing of evidence. Full stop. Para. In view of the above, comma, the writ petition is dismissed. Full stop. The petitioners would, however, be at liberty to approach the appropriate civil court for redressal of any existing grievance in accordance with law.
Much like my lordship, it is just 5 to 12. It should be 7 to 12.
Not 5 to 12.
Seven to
7.
7.
Yes, that's
Like
yes, Mr. Sinha.
My lord, here, my lord, there are connected appeals, the outcome of which will have some bearing, my lord, on the.
Connected?
My lord, appeal, issue, my lord, pending before the division bench.
Okay, yes.
Lord, there is no stay, my lord. And also retables are not admitted till date, my lord. But the honorable.
Hearing is fixed, my lord, not admitted.
Not hearing, the admission, my lord. In the
Admission hearing, matter has been heard
But the thing
already.
is that the thing is
What is
that
the issue?
the
Lord,
issue is that
issue with regard to the
Let-
power and jurisdiction of the registrar to interfere in the matter of the appointment and removal of his secretary, chief executive.
appeal, my lord, whether
In fact,
appeal lies or not.
The learned single judge in another case, in a detailed, my lord, manner, has, my lord, laid down the proposition, my lord.
The appeal is filed by them or whom? You have.
No, appeal, my lord, in some other cases, the Register of Cooperative Societies has also filed 2 appeals. And the other effective parties, my lord, have also filed. And my learned friend is also privy to that, my lord, those appeals.
Yes.
In all the cases, he has appeared.
But there is, my lord, no stay or
Okay,
appeal.
we'll wait for a while. Heard Sri B. Sinha, Direct Counsel for the petitioner. Also heard Sri S.K. Talukdar, Learned Standing Counsel, Cooperation Department. And you have for Khan for,
Response number 5.
as well as Sri M. Khan, Learned Counsel for Response number 5, para. The Standing Counsel has informed that the issue involved is presently under consideration before the Honorable Division Bench. Full stop. Sri Sinha, the Learned Counsel, has submitted that though such proceeding is pending, comma, there is no interim order passed by the Honorable Division Bench. Full stop. Para. Be that as it may, in the fitness of things, this court is of the opinion that the present adjudication process is required to be deferred by 2 weeks. 2 weeks, 2 weeks, full stop. The liberty is granted to the.
My lord, that writ appeal has been fixed and after vacation.
1710.
17th.
17th.
To be listed in the 3rd week of 1, 2, 3. 1710.
1710. That's why.
In the 1st week of November 2025, as this court has been informed that the next date before the Honorable Division Bench is fixed on 1710. Full stop. Para. Liberty is, however, given to the Learned Counsel for the parties to make a mention of this matter if there is resolution of the dispute by the Honorable Division Bench in the meantime.
My lord, to adjudicate properly, the records of the case may be necessary because there are some disputes, my lord, regarding the
Get
resignation.
the records.
My lord, in fact, there is observation, I can bring it, my lord.
The Learned Standing Counsel may also procure the records of the case
Obliged, my lord.
by the next date.
Welcome.
May I please, Lordship? Also, the covered case as per item number 3 today.
Yes, what do you say?
No show cause notice.
the notification has been put under challenge for the Honorable Apex Court, Lordship. And also in the division bench of.
Is it covered by same?
No show cause notice.
Notice has been issued by the state, Lordship.
Yes.
Lordship, here the notification challenge is one of the coordinate bench, Lordship, interfere. It is before the division bench filed by the central GST, and the said notification is also before the apex court, Lordship.
If I may clarify, Lordship, twofold challenge. One challenge is there was no show cause notice as per section 73. Another challenge is that time limit as per the notification which was extended, it is invalid. So far as the notification part is concerned, it is challenged in Supreme Court. So far as the show cause notice, if the show cause notice was not given, entire thing goes, Lordship. I do not press the second one. Similar to the item 3 to pass today, Lordship.
What was 3?
That Mishra had appeared. Covered case, no show cause notice as per section 73, Lordship.
If it is the same case, Mr.
Without touching the notification aspect, Lordship.
3 we do not, we have to check what orders we passed in 3.
Perhaps it was submitted, we can check it. Both of us.
Mr. Chaudhary, if you just check the item, if it is covered, we'll dispose this of.
Notification to Hennigan, no show cause
Ready.
notice.
Okay. You have a similar order?
Lordship, the same one, the item 3-1, I will check it now.
You check it, okay, if it's covered. Rest to know how more meeting has got. There are 2 items fixed. Yesterday's matter approval may not be possible today. Mr. Polita.
We will do the necessary changes, Lordship. We will
Yes,
point
yes,
it out
yes,
to the
yes.
court master.
Plus, Mr. Chaudhary.
We will see.
Two items we thought that we'll be able to complete today's matters, it will not be.
Regarding 47, my lord, yes.
UCO Bank and your matter and your SBI matter.
My lord.
Yes, what do you do?
Lord, next week, my lord,
Next week, this court will, in the division bench.
my lord, I am submitting the list of dates, my lord.
No, that is, we have to rise now. Where is your counterpart? Where? Oh, here. Have you given us a chronology of dates? Yes, your matter, I think we can fix for,
It will be.
we can
helpful
reserve for
your
judgment.
lord.
We can reserve for judgment, I think.
My lord, 48, can it be parted, my lord, since 2 occasions?
Parthad will not be there next week. Parthad will not.
My lord, on 2 occasions, my lord,
I thought we'll finish up today, but today will not be possible.
next week, my lord.
Next week, this court is not there.
No,
It's on division bench.
Third,
Okay,
last week, my lord.
Item number, UCO Bank 2.
Item number 47.
47, madam. Hearing.
Both the learned counsel for both the parties have furnished chronology of events.
24th, no, 24th, 23rd or 20.
The hearing is concluded and judgment is reserved. Yes, he'll give
My
it.
lord, 48, 23rd or 25th, my lord.
But it will not be parted.
My lord, 23rd or 25th, 23rd.
23rd, what is it like? 23rd, 25th, not to be treated as parted. If you are here, we'll decide.
My lord.
Okay. Rest, if there is any urgency, you can make a mention for the court master, will give dates.